27 চলে নাকি দেখ ঠিক করুন 22 করুন
আছে বহুদল ছেলেটা আছে
ইয়েস sorry I can't follow.
My lord, praying for consideration of my representations, your lordship has already passed similar orders, my lord. Those were supposed to appear today, so I made all the bookings and I'm come for the matters. Well, it is not appearing, so pray for.
iPad. Yes. No, sir, I cannot take out of the list.
No. Praying for inclusions and new motions. They were supposed to appear today. And not appearing.
Supposed to appear today, how?
Well, the dates were given today, so it is not there, my lord. These are the consideration of my transfer application representation. Lordship has passed it. I can hand over the corrected copies also.
That is all right.
Yes, my
But
lord.
the thing is, will I be able to read?
This one page order, my lord. This is all consideration.
Maybe
Yeah.
I cannot give preference or precedence over other
No,
matters.
I'm praying for
It's not-
inclusion. I'm praying for
It's not
inclusion.
such a matter that demolition will.
No,
take place.
not at all. I'm praying for inclusion in the list, my lord.
Very well. Today is the first day.
Yes,
It will appear for the first time.
first time, new motion.
Kalke diye din new motion.
Lordship, these are also transformative. These were supposed to appear on second. These were supposed to appear on second, but till date it has not been listed, Lordship. All transfer matters.
I'm grateful to you.
How many?
12 matters. 12.
12 matters. I will not be able to take up, then I will take up the transfers for whole the day.
Lordship,
other matters.
this was supposed to appear in the.
Maybe
second.
I can give you two. Two tomorrow.
Tomorrow.
Lordship,
Tomorrow, two matters.
No, this was all supposed to show on.
Maybe. Give me two, I don't mind. I'm giving, I'm writing it at 6:30 in the evening. I will be there. If you come, then do the matters. 6:30. Transfers matters, 12 matters, and the entire day will be blocked for that.
These are all guided by your.
Maybe.
You will
Maybe
make the
you
corrections
come.
and all.
Maybe very well. You come. Give 3 matters for tomorrow.
3 matters.
Give ticket mark. Give the slips for 3.
Lordship,
My lord, what?
Give the slips for 3. Give the slips for 3. Separately or tear it out and give 3.
your lordship,
My lord,
You were in law college.
New test. Interest of
How many?
80. 80.
1-8. Give the slip, let me see.
My lord, there is a matter where we are petitioner in person, my lord. It is a hearing matter, I understand, my lord, but from 2023, my lord, it is a very small issue whether a particular provision is constitutional.
Let me work on the pending hearing matters which are in the list that
Lordship, it may be
all these matters were called on. Either nobody appeared, 2 days, twice it was
My lord,
called on.
it is
Either nobody appeared or somebody took time.
My lord, I
Next.
have been mentioning this for 2 years. my lord.
lordship, with your permission, lordship.
This matter only, my lord.
Next.
This matter and here this
This
matter.
This matter.
Yes,
My lord,
These are very
We are lawyers.
advanced.
We are also, I am member of supervision since
My-
1981.
You are appearing for person.
Person.
In person.
Sorry, sir. Let me work something on my pending hearing list then.
My lord, your lordship,
But give notice and affidavit of service, otherwise I will not be taken.
lordship, extension of interim order, lordship.
Expired,
Expired, lordship.
application filed,
Made, lordship.
application filed.
Yes, lordship.
Tomorrow application.
My lord, may I be?
Analog as such, huh? Tinte.
My lord, may I be permitted to mention?
Oh, আপনি right, madam. Right, আজ থেকে তো আপনি এসে আমি তো ভাবছি কি হলো তুমিও বুঝবে ঠিক আছে
My lord, may I be permitted to mention one application, my lord, my goods are detained with GST authorities, my lord. In spite appropriating the penalty from me, they are not releasing the goods, my lord. I filed an application after being directed by lordship to do so, my lord. If that can be listed, my lord.
application.
My lord.
So asking for disposal of the writ
Disposal,
petition.
my lord. Last week I mentioned them at your lordship's detail.
Application, give it tomorrow, let's.
Lordship.
Content from my order. My order. Tomorrow content, দেখি day after tomorrow.
Lordship,
Tomorrow, first time. Oh, কালকে দি-
Lordship, this.
Lordship, may I be permitted to mention, these are new motion, it was supposed to be listed on 4th of this month, but. it has
Wait,
not come to the list.
come on, আচ্ছা ঠিক আছে,
Lordship,
give there, how many?
2 matters, my lord.
Day after tomorrow, new motions.
Lordship,
কিন্তু
may I-
শোনো, ও দিদি, আপনি তো জানেন কোনো প্রিসিডেন্স দেওয়া নেই। এর মামলা কিন্তু যেমন সিরিয়ালি আসবে সেরকম নিউ মোশনে থাকবে, বাট ওই কালকে বলছি মানে কালকে টপে থাকবে তা নয়, টপ যেটা থাকবে আমি বলে দেবো, এগুলো সব থাকবে নিউ মোশনে, বাট অ্যাজ ইট ইজ আগে এই মামলা থাকবে, তা যেমন আমাদের বাকিটা তো আমাদের হাতে না, সিআইএস সিস্টেম থেকে হবে। ইয়েস,
Permission to mention a matter, my lord. This matter pertains to appointment on compassionate grounds. The father of the petitioner died in 2020.
now kids, when it appeared last
Last year, my lords. Thereafter, it has not appeared even.
motion,
Yes, ma'am.
so give motion. Acha, one thing, I'm including the matters at new motions, but if I find those appeared before other previous circuit bench, then it will be adjourned for 1.5 years.
It is a
If I find any one of those new motions which had appeared previously, it will be adjourned for 1.5 years.
Lordship, may I
Lordship,
permit-
may I be permitted to mention?
Lordship, this is tender matter, two matter is a tender matter, both are identical matters.
Hearing matter,
No, motion matter.
new motion,
No, not new motion.
pending motion.
Yes.
You wait, sir. How many motions are there in the
Humble
list?
request list matter is.
No,
is
next.
long paid.
Extension of interim.
You have taken out application, huh?
Yes, ma'am.
Lordship, may I be permitted
Tomorrow,
to mention?
এই extension of interim order কাল দিয়ে দেবেন।
Lordship, this is a new motion, Lordship. It was appeared before the last circuit, but on that day, opposite party has taken 1 day.
All
accommodation.
right, madam, so let me do my work on the motion heading,
Lordship, there is
then
an
we-
unauthorized construction, Lordship. Kindly take this matter.
restoration, কালকে দিয়ে দিন application.
My lord, pending motion, it's the hearing matter, my lord.
11 has been-
Next,
Lordship, may I permit to
sorry, sir.
mention matter, Lordship, another heading motion, Lordship. Lordship, this matter lastly appeared, Lordship.
Mr. Counsel, let me do some work on the pending motion list.
Lordship,
Where will I accommodate? Please wait.
Your Lordship, may I be permitted
Let me do at least 25 matters out of the motion and as much as I can from the new motion then.
Your Lordship, may I be permitted to mention one motion matter, Your Lordship? Earlier, the matter was heard and there was a
Sorry, madam,
petition. It's
next.
a police in action matter,
Next.
Your Lordship. The petitioner is being harassed,
Huh?
Your Lordship. The petitioner
Did
is
not
being-
appear earlier,
Lordship.
the day after tomorrow.
Lordship.
No, give the slip, day after tomorrow.
Lordship, may I be permitted to.
If you give the, slip the name day after tomorrow, give the slip. Sir, madam, I will not kindly give for day after tomorrow if you are agreeable. Give the slip. Madam, let me call the list, then you mention whatever you want to say.
Hearing inclusion.
Hearing,
There was a direction for affidavit, but till the affidavit.
all right, I cannot, sir. Next,
Lordship, may I permit to mention new motion matter,
The
Lordship?
list, my lord.
why new motion? It
Not
did not appear before.
No.
Day after tomorrow,
Lordship.
লিখে রাখুন, new motion, day after tomorrow. New motion, গুলিয়ে ফেলবেন না, হ্যাঁ, motion and new motion.
Lordship, may I
be
permitted to mention it? Lordship is a new motion, Lordship.
Day after tomorrow, it did not appear previously.
No, Lordship.
If any matter I find previously appeared, then it will be adjourned for 1.5 years. অনেকগুলো আছে, immediately ফেরত, একটা লিখে রাখুন,
Lordship, three only.
Maybe included.
only one. One.
ये तो
Give a
सही है।
fresh slip, one, হাসছে,
Lordship,
New motion.
নিজেও বুঝেছে, হেসে ফেলেছে ওই জন্য। Yes,
Lordship, kindly it will be included in the list.
What?
There was a direction for affidavit.
yes, it will be included as hearing. Next,
a new motion.
when, why? Previously appeared.
No, my lord, this circuit I given date for second, my lord, not appearing in the list,
Okay.
my lord, new matter.
Give it one matter, give it,
But two matter, same matter, my lord, analogous matter.
all right,
Analogous.
give it one matter for day after tomorrow.
My lord, analogous matter, my lord.
First you give it
Ah,
one
shit.
matter, then next.
My lord,
Control
may I,
wisdom.
my lord, may I permitted to mention one matter, my lord?
Yes,
My lord, new motion, my lord. This was filed in the last circuit when but has not appeared till date. New motion, my lord.
madam, sir, it will appear under the heading motion because
New
it was
motion, madam.
filed earlier, but
No, my lord.
let me do
It
some
has-
work
it
on
has
the
been-
motion
it has
list
been
then.
filed- no,
Next.
Just wait. It is
My
new
lord.
motion, my lord. It has
My
not
lord.
appeared
Lordship,
yet.
may I leave,
Next,
Lordship, may I leave to mention one matter?
yes, please.
Lordship, there is an adjourned motion relates to,
Well,
Yes.
my
Lordship.
fresh motion
Yes, yes.
My lord, may I
My
be
lord,
permitted to
Lordship,
mention
may I
one
leave to
authority has
mention
not
one
appeared till
matter?
date.
Urgent motion I will
Please.
not include now.
My
My
Let
lord,
me
extension
do
of
my,
interim
my lord.
let me
Mine
complete
is,
some of the listed matters then. Next.
mine is new motion, my lord.
Lordship, may,
New motion, not appeared.
Sir, let me complete my motion and new motion which are in the list, sir.
Well, it is also new motion, my lord. I am covering one
Sir, I will
last week.
consider, sir.
One week
Yes.
time or something. Similar
Lordship,
order I
may I
can pay for, my lord. It
Yes,
is a,
yes, next.
My lord, may I
May I take your lordship leave to mention, my lord?
interim order?
My lord, one
Sir, if
urgent
you
matter, my
don't-
lord, may,
Please.
my,
Yes.
lordship,
My
may I
lord,
take your
may
lordship
I
leave
leave-
to mention, my lord, if somebody, my lord, one
Sir,
matter, my
urgent
lord.
motion I will not include.
No, not
Next.
adjourn,
my lord.
my lord, may I take your lordship leave to mention one matter, my lord, extremely urgent matter. A matter relates to appointment of a trustee in a Jalpaiguri temple committee. In first round of writ application, my lord, there are direction that the appointment should be given, my lord, after the resolution taken by the board of trustee will be.
How
my
will
lord,
you maintain a writ petition?
my lord, my lord, the thing is this, my lord, in earlier writ petition, my lord, there is a search committee was appointed. So by the district judge, the search committee was given a power, my lord, to scrutinize the, my lord,
Is it
resolution
an
taken by.
Article 12 authority?
My lord, the district judge is the party, the DM is the authority, my lord, district judge is the party, my district judge, my lord, is the authority who has authorized to give appointment by virtue of a rules
So
framed
which
under the
means,
scheme.
which means it's a Article 12 authority.
My lord, the earlier writ, my lord, there was a, my lord, this writ application is virtually, my lord, for implementation of the order passed by the earlier writ application. My lord, the earlier writ application, my lord, there was a direction given in one way, my lord, the authorities are acting in other way. That is my grievance, my lord. I am filing it today, my lord. I am supplying the number, my lord. Let it be listed on day after tomorrow. Or
Oh, you have not yet filed.
My lord, I am taking leave to move the matter on day after tomorrow, my lord.
Sorry,
If I
you first file and obtain the number, then mention tomorrow. Yes,
my lord,
next.
I'm great.
My lord, may I be permitted to mention in person, my lord?
No leave granted, you file, obtain the regular number, then. Yes,
My
next.
lord. I'm
My
coming.
lord, may I be permitted to mention one matter in person, my lord? My lord, it's an application for interim order, my lord. I'm praying for inclusion, my lord.
Application for
Extension of interim order, my lord.
tomorrow.
Grateful, my lord.
Give the slip.
Lordship,
Yes, my lord, my junior is
Lordship,
handling.
Application.
Grateful.
Next.
Lordship, may I leave to,
My lord,
Yes.
my
may I
lord,
leave to mention,
my lord, one new
may I-
motion matter.
Yes.
My lord,
Yes.
my lord, may I have your lordship's kind leave to mention, my lord, one new motion matter, my lord, for enlistment.
When you have filed.
My lord, last week.
Huh?
Last week, my lord.
During this circuit.
My lord, in between, my lord.
What is in between, madam?
My lord, in between, my lord, at that time, my lord, no bench was available, my lord.
So, all right. What is the urgency?
For urgency, my lord, the vacancy will be filled up, my lord.
What vacancy?
My lord, vacancy of Emma dealership.
When it will be filled up?
My lord, the last date is, my lord, within 45 days it has been given, my lord.
And
my
the
lord,
last
it is
date
going to
when?
complete. My
When
lord,
is
it is going to complete, my lord. It is going to complete, my lord. Kindly take up the matter, my lord.
When is the last date?
My lord, it is under process, my lord.
Very well. Mention when the next circuit will be in the process. Yes.
Lordship,
Next.
Lordship, Lordship, may I leave to mention one, this is of course an adjourn motion, but the matter is relates to a proposed medical college.
Next. Cholo, leads Dako. Sorry.
My lord, I am appearing on behalf of the petitioner led by Mr. Torun Chatterjee. He's appearing online.
My lord, in the last order, in the previous order, small
Why it is
correction is
appearing to
needed.
be mentioned?
My lord, for correction.
What correction? Show me.
My lord, yes.
My lord, in the second para of the last order dated 2nd September 2005, instead of adverse, it is written advance in it.
All right.
Let's look.
The writ petition appears under the heading to be mentioned at the instance of the petitioner.
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 Your lordship.
All right. আচ্ছা মাথার উপর লিখে দিন তো ওই অ্যাপিয়ারেন্সটা একই আছে করে দেবেন হীরক বর্মন একই আছে করে দেবেন এবার লিখুন at the instance of the writ petitioner to correct an apparent typographical mistake on the face of the order dated September 2, 2025. Paragraph. In the penultimate line, in penultimate line of the third paragraph, at the first page of the order dated September 2, 2025, the expression quote unquote advance shall be replaced by and read as quote unquote bold adverse paragraph. The rest of the order remains unaltered and without any modification. Full stop. Paragraph. This correction shall be incorporated in the order dated September 2, 2025.
Oblige, Your Lordship.
Thank you, sir.
Oblige.
Appearance একই আছে দিদি সব করে। Next. Next.
Lord, I beg to appear on behalf of the petitioner, my Lord.
What is the correction?
My Lord, matter
We
was
mentioned-
directed to be appeared as to be mentioned during the next second Monday of the circuit.
Yes.
Justice.
What was the
Past
reason?
land acquisition matter, your lordship, I have already dealt with this matter, my lord.
Let
Kindly-
me see what is the direction second Monday.
Passed by Justice, His Lordship, Absolute Justice Raja Basu Chaudhary. No.
Yes, report.
In this matter, the land.
Report. Give me the report.
Land was engaged on the last session, was asked to appear.
Huh?
Double AG was asked to, by your lordship, was asked to appear in this matter.
What is the report file করতে কি অসুবিধা? Give me the report. File the report. File the report.
Proceed, seek for some password.
File the report. I will adjourn. File the report.
We are not carrying.
File the report. Who was there? Shubinoy De, Debanjan
Lord,
De,
what
and Joyjit Chaudhary, yes. Shubir Kumar Saha, Hirak Bormon, Anirban Banerjee.
He was there.
Give the report. File the report. Yes.
I am seeking for short password.
No question of Passover. File the report. Report you have to file, then I shall give you time. No worry. File the
I am
report.
not carrying the report. I take instruction from.
No question of taking instructions, sir.
I was not there. So I seek short password. I will talk with him.
Sir, that's not my practice, sir. You know. File the report.
Definitely.
File the report. You will file the report. I will adjourn. No issue.
No, we are not seeking adjournment, just passed over.
But I will adjourn the matter because he has to give he has to be given opportunity to deal with the report.
My lord,
Have you been served with the report?
no, my lord.
So please wait. Give me the report. Give him a copy.
I am not carrying the report. I seek for short passover because planet, the origin is moving in the matter. He is leading us.
So what the report he will file? I'm not asking to do the matter. I am not on the matter. But give the report. File
I'm
the
seeking for short, I will talk with him. He is not, he is arrived.
talk to him and you just tell him that the report has to be filed now. I will take the report on record and adjourn the matter. No problem. But you have to file the report now. File it. I'm waiting. Go and ask him. You have to file the report. Go. I'm waiting.
If I may take your lordship to the order dated,
Will you take the report or not?
my lord, I shall.
So why you are making your submission, sir? First you look at the report.
My lord, I shall.
Nakun, next matter.
Lordship, I want to observe this application.
Okay.
Divert to file a fresh.
MS? MS?
Shantani Das.
Shantani Das, learned advocate, appearing for the petitioner, submits that she has received instruction from the writ petitioner to withdraw this writ petition and to file afresh on the self-same cause of action. Where is your instruction, madam? In writing?
Writing, there is no instruction.
She has confirmed this court that she has received instruction verbally from his client, from her client. Paragraph. Mr. Novankur Pal.
Lord, I am appearing for the state.
Oh, Mr.
Arjun Chaudhary.
Arjun Chaudhary, learned advocate, appears for the state. Paragraph. Paragraph. Mr. Novankur Pal, learned advocate, also appears for the state. With Mr. Sandeep Guharai, learned advocate. Both the learned advocates appearing for the state say that there is a confusion who is actually representing the state. Full stop. Be that as it may, that is not the lookout of this court at this juncture. Full stop. Paragraph. Accordingly, this writ petition, bold, WPA 1684 of 2025 stands dismissed as withdrawn with liberty to file afresh on the self-same cause of action.
For Lordship, I'm for the petitioner.
Actually, at this juncture এর আগে একটা comma. Yes. 4.
For Lordship, I'm for the petitioner, Lordship. Lordship, this is the commuted value, Lordship. Lordship's order is there.
My order?
Yes, Lordship's order.
You have seen, Mr.
My lord, MS Vedasruti was actually along.
MS Vedasruti Ghosh, learned advocate, bracket VC, with Mr. Sandeep Guharai, learned advocate for the state. আর ওর নাম দিয়ে দিন MS
Tanya Bhumi.
Tanya Bhumik, learned advocate for the petitioner.
Five also, Lordship, same. Commuted value.
Mr. Sumit Kumar for the state. Witness MS Pratyusha. If anybody is on VC, just mention so that. Acha, Pratyusha Pashe Vacating VC. VC. Just mention that. VC. Next.
Grateful, Lordship. Lordship, I am for the state, Lordship, item number 6.
Next.
6 also same, Lordship. The commuted value. Lordship's order. And if
Mr.
Lordship, in item number 6, I am for the state, Lordship.
Are give your name, sir?
Pradeep Sarkar.
Mr. Pradeep Sarkar, led by Mr. Shubir Kumar Saha, learned additional government pleader. Pradeep Sarkarer pashe VC for the state.
Grateful, Lordship.
Next.
seven, same, Lordship.
State ke.
Only one penalty.
Give your name. If anybody is on VC, then give them, mention that. Only one is on VC? All right. Next.
Same lordship. Lordship's order.
Tania Sarkar,
Tanya Bhumik. Lordship.
Tania Bhumik. Shubir Kumar Saha, landed additional government pleader with Vikas Shingo, landed advocate, appears for the state. Next.
Nine, same lordship. I'm for the state.
MS Rima Sarkar, who is senior? Mr. Hirok Bormon, landed advocate with MS Rima Sarkar, landed advocate, appears for the state. Where Mr. Bormon has gone? Outside. ঢুকবে না এখন।
My lord, in item number 10, I am for the state led by
Next.
Mr. Pritam Das.
Same lordship, commuted values.
My lord, in
Pritam-
item number
Das.
Pritam Das along with Kumar Santanu.
Mr. Pritam Das, landed advocate with Mr. Kumar Shantanu, landed advocate, bracket VC. Kumar Shantanur pashe VC. Get for the state.
Same lordship. For commuted values, lordship's order.
ওই
State
দিদি
preparation.
ওই প্রীতম দাস কুমার শান্তনুর পাশে ভিসি।
Declaration.
Don't worry, you are taken care of in these matters.
Same lordship. Lordship's order. What is it?
Navankur Pal, Rima Sarkar. You are there, sir? Mr. No, Shaha, Mr. Shah. Yes. Next.
Thirteen also same. Lordship's order only.
I'm for the state along with Mr. Kumar Shantanu.
Anirban Banerjee,
Yes, yes.
Kumar Shantanu,
I'm
Kumar
there.
Shantanu VC.
Fourteen also same. Lordship's order.
The Shondil Gora led by Lanteji.
Mr. Shubir Kumar Saha, landed additional government pleader with Mr. Shondip Gohara, landed advocate. When he is present, his name should be go first.
Fifteen same lordship. Commuted value bench.
My lord,
Services
Mr.
order.
Hirok Burman along with Mr. Kumar Santanu.
Where is Mr. Hirok
Mr.
Bormon? দিয়ে দিন কুমার হীরক বর্মন with Mr. কুমার শান্তনুতে ভিসি করে দিন।
Republic.
16 I am for the petition.
দেবজিৎ কুন্ডু চেঞ্জ হলো, হ্যাঁ, দেবজিৎ কুন্ডু, মমিনুর রহমান, landed advocate with Mr. Vikas Shingo, landed advocate for this.
Item number 16, I am for the state along with Mominur Rahman, Your Lordship.
Are
I'm appearing virtually.
Be called up.
16 is running, your lordship.
16.
I am appearing.
Dara. 16 you are there.
Yes, I am.
Vikas Singh with Mominur Rahman and a comma দিয়ে দিন প্রত্যুষা দত্ত কি চৌধুরী ব্র্যাকেটে ভিসি anybody else?
No, your lordship. Right.
Next, Devojit Kundu, Mr. For the state. My order?
Yes. Single picture.
Hirok Burman and on it.
Where is he? Hirok Burman, Anirban Banerjee. Yes, Mr. Hirok Burman, Anirban Banerjee. No, but then his name must first go. Mr. Shubir Kumar Shah, learned additional government leader with Mr. Hirok Burman and Anirban Banerjee, learned advocates for the state. Next. Next. Devojit Kundu, Mr. Who is for the state? 19. Hirok Burman for the state. Next.
For the state, my right.
Rima Sarkar, landed advocate with who is senior? Oh, both are same. And Rima Sarkar and Vedasruti Bose. Where is Vedasruti Bose? VC? VC. Vedasruti Bose, bracket VC.
My lord, I am for the state led by Mr.
Devojit
Subir Kumar
Kundu,
Saha.
তারপর লিখুন দেবজিৎ কুন্ডু, তারপর লিখুন সুবীর কুমার সাহা, লার্নের অ্যাডভোকেট, অ্যাডিশনাল গভর্নমেন্ট লিডার উইথ কুমার শান্তনু, লার্নের অ্যাডভোকেট, ভিসি ফর দ্য স্টেট.
Deeply obeyed.
Sumit Kumar, Devojit Kundu, Sumit Kumar for the state.
Along with
Sumit Kumar and Saurabh Sarkar, learned advocates for the state. Devojit Kundu,
Napankur Pal with Vikas Singh.
Napankur Pal, Vikas Singh. দেবজিৎ কুন্ডু, মমিনুর রহমান,
প্রত্যুষা দত্ত চৌধুরী।
প্রত্যুষা দত্ত চৌধুরীটা ভিসি হয়ে যাবে ব্র্যাকেটে.
Great for your
Next.
It's a hero hormone along with shoulder shampoo.
Devojit Kundu, Mr. Shubir Kumar Saha, additional government pleader. Pratyusha Datta Chaudhary, bracket VC.
Grateful much.
Devojit. আর কি প্রদীপ সরকার ভিসি এই এসিটাকে ঠিক করো না না ওর জন্য না নিচে নামিয়ে দাও দাও আমায় দাও আমায় দাও Yes.
I'm for the respond number 2 and 4.
Yes.
This is the restoration application. This is my service now.
29.
What happened to that matter? Yes.
28, my lord.
Mr. Shah, sir, what happened to that matter? What is the instruction you have received?
Yes, madam. Yes, my instruction has come. Then look, here after download data. It comes with the guidance.
Next.
This is application for restoration, madam.
When dismissed, when application taken out, within time?
Yes, madam, within time. On 12th August, it was madam. Within time, madam.
Yes. Ashun. Can 1 of 2025.
My lord, I'm appearing for responding number 2 and 4.
Miss, what is your name? What is the name?
Hillol Shah Poddar.
Mr. Hillol Shah Poddar for the petitioner oblique applicant. MS Rima Sarkar, learned advocate for the state.
No, not for the state, my lord. For
Respondent number?
responding number 2 and 4, my lord.
2 and 4. And you are there, sir?
But his name was there earlier when it was dismissed.
Mr. Shubir Kumar Saha, learned additional government pleader, appears for the state. ঠিক আছে, হিল্লোল শাহ পোদ্দার লিখেছেন learned advocate. This is an application for restoration of a writ petition which was dismissed for default on August 12, 2025. Date bold হবে, huh? And the application has been taken out on August 18, 2025. Paragraph. Sufficient cause being made out. The sufficient cause being made out. The order of dismissal dated August 12, 2025 stands recalled. Paragraph. The writ petition stands restored to its original file with number. Full stop. Accordingly, can 1 of 2025 stands allowed without any order as to costs. আচ্ছা মাথার উপর affidavit of service filed in court today is taken on record. Next. Next.
Yes, Lordship. I'm for the added respondent number 24.
I'm for the
এই আমাকে একটা দিদি ওই দুটো সাদা কাগজ স্টেপল করে দিন।
I'm for the writ petitioner. I led by Mr. Joydeep, but he's on virtual mode.
All right.
Lordship, in this case, I
I
have
filed my
filed
reply, opposition, I accept them.
No, opposition in application.
Yes.
Application.
application. I have filed an vacating
No,
application.
no, you have been served with an opposition.
Yes, Lordship.
You have filed any reply.
No, Lordship.
You will to, you,
No,
you
no.
wish to file any
No,
affidavit
no.
in reply?
No.
All right.
It doesn't. Mother vacating old vacating. I did vacation.
Did.
Lordship, may I hand over the order sheet against which I have filed the vacating application?
It's not there in the vacating.
It's in record, but not in the vacating
All right,
application.
let me see. Let me see. Wait, wait. So which is the vacating effectively? Can 5?
Yes, can file.
Yes, Lordship.
This is the opposition. Asking vacating for 12th August.
No,
12th
Lordship, can 4 is vacating application.
12th July.
12 July 2024.
Yes, 12th July. Wait. Can 4 is the vacating?
Vacating, Lordship.
Five is a.
No, 4 numbering na change karke isko. Filing section.
So this is your affidavit, Mr. Rai.
Mine is my opposition.
So it's written as can 5. So correct it. Doesn't matter. Correct through your advocate on record. Ask him to put his signature. Ashun. Where is Mr. Kaur?
Lord, I appear, Lord, for the writ petitioner, Lord, I'm opposing this application for vacating the interim order.
All right. Mr. Joydeep Kaur, learned senior advocate, bracketed VC, with Mr. Omolesh Rai, learned advocate, appearing physically appearing for the writ petitioner, opposing this vacating application. Full stop. Paragraph. MS. Supriya Singh, learned advocate, appears for
Respondent number 24, Lordship, added respondent, but
added respondent number
24.
24.
Lordship, but in
You are a private respondent?
no, Lordship, government, for the Director Asian Highway 2.
Wait.
But I also appear on behalf of the National Highways also.
Wait. National Highway, which respondent?
Respondent number 6, Lordship. 6 and 7.
Supriya Singh, learned advocate, appears for respondent number 6, 7 and 24. Paragraph. Collectively, the National Highway Authority. Bracket close. Paragraph. Acha. এরপর লিখুন কি বললাম respondent 5, 6 and 24 in the writ petition. Slash in the writ petition bracket oita collectively for the National Highway Authority, bracket close, slash applicants in this application. ঠিক আছে? এবার লিখুন this is an application. এটা in re করে করুন দিদি. In re can 4 of 2025. In re can 4 of 2025. হলো? লিখুন। আচ্ছা ও তারপর লিখুন অ্যাপিয়ারেন্সে মিস্টার সুবীর কুমার সাহা, learned additional government pleader, with Mr. Mominur Rahman, learned advocate, appears for the respondent number
145
1,4,5 7,8 7 and 8 in the writ petition slash state. হলো? তারপর আর একদম শুরুতে হচ্ছে ইন রে বলে ক্যান করেছেন। এইবার লিখুন this is an application praying for vacating of an interim order dated July 12, 2023, passed at the instance of the writ petitioner. Paragraph. On the prayer of Mr. Omolesh Rai, learned advocate appearing for the writ petitioner, time to file affidavit in opposition in the instant application stands extended till today, full stop. The affidavit in opposition filed in court today is taken on record. Full stop. Copy has been served upon MS Shupriya Singh, learned advocate, and the learned and at the office of the learned additional government pleader. Yes, proceed.
Yes, Lord. Lordship, in the year 2023, this interim order was passed in absence of the added respondent number 24, Lordship, because this acquisition.
Who is 20? Who was
Asian Highway, Lordship. They have made the National Highways Party, but the entire stretch is initially acquired by the NS31, but subsequently handed over to the Asian Highway for construction of the 4-laning and 6-laning, Lordship. It is a time-bound project, Lordship. Within 19 September of 2025, we have to complete the entire stretch for 4-laning, Lordship. Lordship, it is an admitted case of the petitioner that 1 acres of the land is acquired by the authority, Lordship. Subsequently, in this writ petition, there was an order by the Justice Hiranmay Bhattacharya for demarcation of the land, Lordship. Lordship, kindly sees the reply which they have filed, Lordship. The order of
No, you first tell me your case, madam.
Lordship, this is the part of my case, Lordship.
Yes, no, first you narrate, then let me hear and then
Lordship,
you say.
in the, after the order of the Honorable Justice Hiranmay Bhattacharya, Lordship, there was a
Hey, shut up.
demarcation.
দিদি এতে আরো 3টে কাগজ লাগিয়ে একসঙ্গে স্টেপে করো।
Yes, there is a field inquiry and demarcation was conducted, Lordship. And the stretch which have acquired by the authority 1 acres demarcated even in the map by putting the red line, Lordship. This is the admitted fact of the admitted. This is the admitted story of the petitioner that 1 acres of the land is acquired by the authority, Lordship. And the only grievance which was they placed in their writ petition that the such 1 acre of the land was not demarcated. But subsequently, everything was done.
What about the compensation?
Lordship, compensation was paid long back, Lordship. The original owner, Lordship. Subsequently, this land was handed over to another person, Lordship. In that 79 decimals of the land is their land, Lordship.
No, wait. When was the first notice of initiation of land acquisition proceeding? Madam, in this type of matters where facts are required, you should have come up with a list of dates.
That's what I have in my phone, Lordship.
Your phone, you will check it up, then I will memorize. Come tomorrow with your list of dates.
Lordship, I have.
So give me a printout. Give me a printout here and now.
Lordship, kindly sees the writ petitioner petition where they have make the list of dates, Lordship. List of dates.
One in 1970 and one in 1987.
19.
Pages.
1950,
Pages. Show me the
First,
pages.
after synopsis, Lordship.
No, the notices where you have annexed. Madam.
Yes, Lordship.
Come tomorrow with, I'm just passing it over, come with the full list of dates with the annexures page. Because this is a matter of importance which simply like that cannot be handled.
Lordship, then kindly direct the petitioner to give the full copy because I have no copy, Lordship, because
What full copy?
full copy of the writ petition, Lordship.
আচ্ছা দেখি আমার রিট পিটিশনটা দেখান ওকে কি আছে কি নেই ও দেখে নিক।
I have filed everything. Check up it. I give it in your my office.
Mr. Roy, you also bring a list of dates. Whatever, please, whatever dates and documents you want to rely upon, right, to sustain the interim order in favor of the writ petitioner. And you bring the list of dates, the entire list of dates, so that, see, the moment, that's the elementary of law which we have learned. The moment you have come up with a vacating application,
Yes, Lordship.
it is more on facts.
Lordship.
It is more on facts. Because if you read the basic provisions under Order 39, Rule 4, it is more on facts.
Yes, Lordship.
Then comes law. So first you give me a clarity and clear picture of the
Lordship, what
facts.
happened, Lordship? I have not received because I was the added respondent. Yeah, they have served upon the copy to the National
Mr.
Highway, Lordship.
Madam, please, Mr. Rai, let her understand. Madam, the moment you have filed a vacating application, you have not filed it in the air. Definitely, just say there is an interim order expert
I have
vacated.
only the read petition copy, not the annexure, Lordship.
But you have your own copy on your record.
Yes, Lordship, but that
So that should be the basis of your asking for vacating. That these are the records, these are suppressed, or these are the records on which this interim order should not be passed or should be vacated at this juncture. These are purely facts.
But in my application,
Well, I
that
just make it short one.
but
so bring the list of dates.
My opposition had given all documents. I've given all documents.
All right, but I need a list of dates.
original
I have got it.
owner, the recorded owner.
Sir, madam, I think better try your luck before any other circuit bench.
No, Lordship. Then keep it tomorrow, Lordship.
I'm simply passing it over. You bring a list of dates. Skill.
Can I just take 5 minutes to summarize, Lord, what the
Mr.
fact?
Kaur, come. Yes, sir, I will hear you tomorrow, sir.
Very
Because
well.
I tell
I'm
you,
not-
that's the basic we have from the
Absolutely.
seniors that
Absolutely.
Both of us
Absolutely.
might have learned from
Of
both
course,
yes, we have learned
These
from-
are-
one of the seniors, of
Yes,
course,
yes.
but all the seniors, whenever we go to the seniors, say, this is a vacating, sir, the first thing comes, where is your list of dates? Because
But,
read Order 39, Rule 4, it is more on facts.
Absolutely. Absolutely.
I'll prepare tomorrow.
Yes, you come tomorrow.
Yes, Lordship.
You bring the entire list of dates.
Lordship.
Bring and give them a copy. And Mr. Rai, you also prepare a list of dates. You prepare a list of dates. You also give her a copy. There is no hide and seek because it's all on record.
Also, to some extent, I also support him. I also, through her, I'll get my order.
Very well. Come tomorrow. I will hear you. It will be a pleasure to hear all of you.
Yes.
Lord, is it my lord's pleasure to keep it on Wednesday instead of tomorrow?
I
mean,
don't mind. I don't mind.
because I think this list of dates and all this, they just.
I'll do it.
Okay. No, Mr. Kaur, you.
I'll not be here. I'll go to Calcutta. Can you take it tomorrow?
Okay, all right, all right. Take it tomorrow. I have no difficulty.
I'll give it.
Absolutely.
In the meantime, I'll send you my notes.
Lordship, since the order was passed in this case, Lordship, can we give our appearance slip?
Okay.
Because
Very well. Done.
All
Done. Chalo, done.
Yes, sir.
At the commencement of hearing, when MS Singh has commenced her submissions, on her vacating application, this court feels a comprehensive list of dates is required. To appreciate the case made out in the vacating application poster paragraph. Accordingly, a comprehensive list of dates with the details of documents and annexures relied upon by the applicant in support of its vacating application, referring thereto, shall be brought on the next day. Full stop. Mr. Joydeep Kaur, Lanet Senior Advocate, appearing with Mr. Amolesh Rai, Lanet Senior Advocate, are also requested to bring a comprehensive list of dates in line of the case, in sync with their submissions to be met. Poster. Paragraph. The matter shall appear under the heading application on Date bolun?
Tomorrow one.
On Tariq. On September 9, 2025. Even if it is understood by everybody, even if the order is not placed in server, it will be taken up tomorrow.
Absolutely, absolutely.
Yes,
Absolutely.
madam? Yes. Bring the list of dates, it will be easier. Because at the end of the day, ultimately the task will be with the court to write the judgment. If I commit a mistake on facts, then the entire thing will be vitiated unnecessarily, whatever. Wait.
Obliged. Perfect.
আসুন এটা রেখে দিন দিদি, এটা একটা ফাইলে সাদা ফাইলে করে মাথার ওই ফাইলের উপর কনস্ট্রাক্টলি দিয়ে রেখে দিন। আর দিদি কে এটা কে দিয়েছে? নিউ মোশন এটা রেখে দিন, পরের দিন যখন এসে বলবেন আমি মেনশন করেছি দাওনি, তখন দেখিয়ে দেবেন। এখন রেখে দিন, দেবেন না কোনো ম্যাটার। ইয়েস
Lord, I beg to appear on behalf of the respondent number 6 and 7, Lord. Siliguri Jalpaiguri development.
Withdrawing the application, my lord. I apologize, my lord.
That my interim order has been expired, I have filed the CAN application, I have served to all the parties, lordship.
When expired? When expired?
It expired, lordship, and it comes to the last order, it has been expired in the end of June 2025.
When you have taken out the application?
9th of July 2025.
Why this delay?
Lordship, the matter was running in the
Can.
CAN 2, lordship, and it's the CAN 2. Lordship, can you see the last order?
Read, Mama.
Page 20, the last order.
আসুন দিদি,
Initial order, lordship, the first.
which page?
Initial order, lordship.
Page 8.
Page 8.
In Re Can 2 of 2025. This is an application praying for reinstatement of an interim order originally passed on March 13, 2024. Acha, মাথার উপরে affidavit of service filed in court today is taken on record. Appearance গুলো সব দিয়ে দেবেন। Originally passed on, date টা bold, সব date গুলো bold. March 13, 2024. The bunch of orders annexed to the application shows from time to time the said interim order was extended. And the last of such extension was on April 10, 2025 at page 22 the application. And the interim order was extended till June 2025 or until further order, whichever is earlier. Paragraph. After the interim orders has expired, this application has been taken out on July 8, 2025. Paragraph. কি বলেছি প্যারাগ্রাফটা? Paragraph. The application has been opposed by the appearing respondents. Paragraph. Considering the case made out in the application, and for the ends of justice, so that substantive justice shall not suffer for procedural error, procedural mistake, or due to the mistake on the part of the learned advocate on record for the petitioner, comma. The interim order originally passed on March 3, 2024 stands reimposed / reinstated, and the same shall continue till November 9, 2025 or until further order, whichever is earlier, subject to payment of cost of rupees 1,000 to be paid by the petitioner applicant in favor of the State Legal Aid Services. Okay, please name the expression. In favor of the High Court Legal Services Authority, comma, Circuit Bench at Jalpaiguri. Within 7 days from date. কি বললাম? আবার পড়ুন। Comma the interim order originally passed. It did the bold November 20. And this, please listen. This authority, name Araba Chechi authority. Within a week from date. Oh, accordingly, the paragraph, the application, koto, number koto, bold, can 2 of 2025 stands allowed, comma, stands allowed. Didi, ita. AG, Matharopur affidavit of service filed in court today is taken on record. Next.
Grateful Lordship.
Acha, Raja Shaha kar hai ache.
But Siliguri Jalpaiguri Development Authority.
Respondent number 6 and 7, that is Siliguri Jalpaiguri Development
Given
Authority.
his name.
I have given his name.
Raja Shah, learned advocate, pashe VC kore din.
Lordship, I am appearing 8 and 9.
Give your names, give all your names.
Lordship, item number 32, I am praying 1 day's accommodation, Lordship.
Which one?
32, next item,
Sir, it's
Lordship.
an application for vacating, my lord. I am traveling from Kolkata, my lord. For this matter.
Lordship, because in this matter, I am led by Mr. Ghosh, Lordship. He is not come today.
Mr.
Vikramaditya Ghosh.
She has come from Calcutta.
Lordship, why he has gone for one hearing in principal bench, Lordship. 1 day's accommodation, Lordship.
No, but convince her.
Lordship,
Who will have to bear the cost and expenses, madam?
Lordship, I requested her, she will stay today.
The
At
cost
my
is
home,
on the
Lordship.
client, my lord. And the
At
petition-
my home, Lordship. I can.
She is assuring that she will be the host.
My lord, kindly fix it tomorrow.
Yes,
It
Lordship.
will appear tomorrow. Passed over for the day. But tomorrow I will have to take it up.
Yes, Lordship.
My lord, 33, 34, I am appearing on behalf of the Siliguri Municipal Corporation.
My lord, there was a direction on the Siliguri Municipal Corporation and SJDA to file opposition. However,
The application.
yes, my lord. However, we are not pressing to the writ petition, my lord. However, we are not pressing the application, my lord, the injunction application.
My lord, there was no direction to file opposition. My lord, rather there was a direction upon senior counsel appearing on behalf of the
My
writ
lord, may I
petition.
just my lord, I am appearing for the respondent number 8. You also kindly see the order dated 4th September. Mr. Prabal Mukherjee appeared virtually. He was to take instructions whether he will withdraw the applications or you will his pass necessary order on the application.
Yes, what, you are the junior of Mr. Mukherjee?
Yes, my lord, he is not pressing the applications. My lord, kindly record this.
That you do not have to submit. Let me hear.
My lord, since there is a resolution, Mr. Mukherjee is unable to appear.
So you appear, you be there.
My lord, I'm led by him, my lord. I'm led by Mr.
So what do you want?
My lord, I'm not pressing the application in the.
All right, so I'm dismissing the application.
My lord, kindly takes it up tomorrow or day after, my lord.
Come tomorrow. Pass over for the day.
Then, my lord, make it day after tomorrow, my lord. Tomorrow I have some difficulty, my lord.
You will appear virtually.
My lord, even in virtually, because I have some matters fixed in the principal bench, my lord. I cannot appear, my lord. That is the problem, my lord. Yeah.
If you have to record an order, then it will go out.
My lord, he is not pressing the application, my lord. That is why, my lord, he is not pressing.
Sir, he is a junior member. He doesn't want to take the burden on his shoulder. Which is appreciable. And you are a senior member, you must appreciate that.
Yes, my lord, I appreciate, my lord. Then
because he might face some. He may be apprehensive that he might face some consequence.
As lordship.
You are a senior member, sir. Now you have to be liberal to that effect.
I'm not objecting. I'm not objecting.
Be there virtually. Let the junior members be spared.
No, I'm only saying instead of 9th, my lord, may it be on 10th.
Come tomorrow. Come tomorrow. Just appear through virtual mode. It's like our school days. Present, please. That will serve. All right.
Grateful.
Come tomorrow.
Grateful, my lord.
My lord, I'm praying for a correction in the order, my lord. Respondent number 2 has to be respondent number 4.
Yes, Lordship. I'm for the GTA, Lordship.
So you by consent.
Yes, Lordship.
Where? Show me which order.
My lord, in the second page, my lord.
Yes.
Second last para.
Second
last para, my lord. From below.
Oh, 2 paragraphs. This is an application filed by
the petitioner, my lord.
Filed by the writ petitioner.
My lord.
Seeking certain corrections, typographical corrections in the order dated January 24, 2025 at page 7 to the application. Poster. Your name?
Ranjan Sharma.
Mr. Ranjan
Sharma,
learned advocate appearing for the writ petitioner, and MS Supriya Singh, learned counsel appearing for respondent number?
GTA, Lordship. Responding GTA.
Yes, all.
Yes, GTA, all authorities, Lordship.
respondent number 4.
Respondent number 4, Lordship. 4 and 5.
Respondent number 4 and 5, oblique GTA. You will know? তারপর একটা প্যারাগ্রাফ
Correction.
GTA have agreed to the corrections to be incorporated in the said order dated January 24, 2025. Poster. Paragraph. Accordingly, by consent of the parties, wherever the expression respondent number 2 appears in the said order dated January 24, 2025, the same shall be corrected and read as respondent number 4. Respondent number 2 chilo to? Bold kore din. Respondent number 4. Paragraph. The said correction shall be incorporated and read into the order dated January 24, 2025. 24 kintu didi order ta January 24, 2025. paragraph accordingly, can one of 2025 stands allowed? Can one to bold?
Item number
ওই চারটে কাগজ দিন তো সাদা স্টেপল করে একটা ফাইলে থাকবে, দাঁড়ান দাঁড়ান 1 মিনিট। আর ওই পাতায় ফার্স্ট পেজটা এইটা হবে স্টেপল করা, আর 4টে পেজ তলায় যাবে, দিন তো। কত WPA কত জানো এটা?
443.
440.
লিখুন অজয় সিঙ্গল, না মাথার ফার্স্ট হচ্ছে MS রেশমি ঘোষ, learned advocate appears for the petitioner, ব্র্যাকেটে VC, রেশমি ঘোষের পাশে learned advocate এর পাশে VC, তারপর মিস্টার অজয় সিঙ্গল for the applicant, learned advocate for the applicant oblique ও না ওই দেখে নেবেন, পুরোটাই বলা আছে, ছেড়ে বসো। Next case.
My lord.
One second. Today we are on?
Today we are on 8.
Yes.
My lord, on the last date, my lord, I had instructed us to bring the writ petition that was earlier filed. My lord, I have brought that by way of supplementary.
Thank you, sir. No supplementary.
But I have not stated
required.
anything, my lord. I have just.
Not required. I said
Because I
you
have paid
simply,
leave,
no.
my lord. And my lord, even the.
No. I have not asked you to produce by a supplementary affidavit. Either you produce or I will say you have not produced.
Lordship, even I was instructed to also produce a copy. My learned junior is with a copy of 1374.
Yes.
The earlier writ petition, and he has the order copy also.
I'll just refer to.
You refer for your own convenience, I don't mind.
Yes. My lord, and a short list of dates, relevant provisions of law, and my brief notes of argument.
Okay. আচ্ছা একটু লিখুন। Today, learned counsel appearing for the petitioner has submitted a copy of the previous writ petition, has submitted a complete set of copy of the complete set of previous writ petition.
Lordship, 1374, your lordship, this is the writ petition, but without the annexure, your lordship. I have only, I could send them the scanned copy of the petition.
All right. কি বললাম? Complete set দেবেন না, copy of the writ petition bracket without annexure.
My lord.
Complete set, my lord.
So give it.
I'll remove this supplementary
Do
part.
that. Give it the complete set. Then I will not record it.
Yes.
but no way by way of supplementary.
I'll remove the supplementary. my
No,
lord.
you do it immediately and give it to me.
Yes.
Who has asked you, sir? I have not asked you to come up with a supplementary.
I thought it could be appropriate. My lord, on the previous date, my lord, I have substantially placed my arguments
Yes,
on
you,
2
you
points.
give me a copy. I don't mind. I will take it.
My lord,
আচ্ছা তাহলে এইভাবে লিখুন Today at the commencement of hearing, Mr. Ajay Singhal, learned advocate appearing for respondent number 9, has placed copy of the complete set of the previous writ petition being WPA 1374 of 2023. The same is taken on record.
my lord, it's stitched.
Yes. Yes.
My lord, in my short notes, my lord, along with that, my lord, I have given the judgments also, my lord. 2 judgments I have already relied upon, my
And
lord.
the second, third you rely
To 1 and 2 I relied. The 3rd judgment I'll place now.
from the list, notes and argument.
From the note.
Yes, place it. Which page of notes?
My lord, last page, my lord. Compendium of judgment. Bond paper, my lord, last page of bond paper.
Sir, I have to read the judgment. So
Yes, my lord, that
take
is-
me to the annexure.
Sri K. Jayaram.
Sri
K. Jayaram, 3rd judgment, my lord. Versus Bangalore Development Authority.
judgment dated
My lord,
8 December.
8 December
Okay,
2021.
wait. Oh, the 2 which you have placed, you have not annexed.
Not any.
Okay.
That was
That-
already submitted.
Yeah, no problem. I was confused that why. No problem. You place in your own way, no issues.
Yes, my lord. My lord, in that judgment, kindly take para number 6.
You have given copies to them? That means
Lordship, on the last day, what he has referred to, I have obtained the copies.
today also
No,
he has
the
been
today's
referring, but you obtained from your,
Lordship, I'll check it here.
Citation number 9.
you obtained from the website.
Lordship, that I'll do. Let my learned friend only give the citation, I'll obtain.
No, the citation is not there. Mr. Dhar,
Lordship, the site.
listen to me.
Lordship.
Take a screenshot of the first page
Lordship.
and the order dated. Send her by WhatsApp. She will immediately get access to it.
Yes. ನನ್ನ 8 ಆರಾಕ್ಟ ಕೊಡ್ತಾ
Yes, paragraph.
My lord, para number 11, my lord. Wherein the certain fact, my lord. Page number 7, internal page 7. Towards last 5 lines. my lord.
Wait.
Para 11, irrelevant at page 7, man. Last part.
Wait. Yes. Yes, sir.
Yes, sir. My lord, it starts with the, admittedly, the appellants had filed OS in third line, my lord, at page 7. Admittedly. The appellants had filed and
Equitable and discretionary, and it is imperative that the petitioner approaching the writ court must come with clean hands. Oh no, that's the 12. Sorry.
11, my lord.
11.
Admittedly, the appellants had filed OS number this before the additional city court against BDA seeking permanent injunction, while pleading identical facts and urging similar ground. The said suit was dismissed by the trial court. The appeal filed against the judgment of the trial court.
Wait. The most important part is I got my answer. Yes.
My lord, thereafter, the appeal filed against the judgment of the trial court was also dismissed by the High Court. The appellants have not disclosed the filing of the suit, its dismissal by the civil court, and the confirmation of the judgment by the High Court in the writ petition. It is clear that the appellants have suppressed these material facts which are relevant for deciding the questions involved in the writ petition. Thus, the appellants have not come with the clean hands. Thereafter, my lord.
Absolutely, I admit.
That is, my lord, I agree. Now, why I have placed reliance, my lord, because all the other was already decided in KD Sharma, my lord. So I'll not waste much time in that. My lord, directly comes to para number 15, my lord, wherein the KD Sharma has been discussed, my lord. All these points I had placed on the previous date. I will not go into that, my lord. Thereafter, my lord.
Para?
16. 15 is the reiteration of KD Sharma, my lord, relevant portion. 16 now. Why I have placed this judgment is for 16. It is necessary for us.
Wait.
My lord, before that, my lord, last part of para 15. That is at page number 11. It is primary object as highlighted.
Yes.
Highlighting in Kensington Income Tax Commissioner Supra is kept in mind. An applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hands. It is suppression or concealment of material facts is not an advocacy. It is jugglery, manipulation, maneuvering, or misrepresentation which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and truly but states them in distorted manner and misleads the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule nisi and refuse to proceed further with examination of the case on merits. If the court does not reject the petition on the ground, the court would be failing in its duty. In fact, such an applicant requires to be dealt with for contempt of court for abusing the process of the court. Para 16 now.
এটা ফাইলটা কালকেও রাখবেন, অ্যাপ্লিকেশনটা যখন শুনবো। On the last occasion, you have placed that KD Sharma.
KD Sharma.
Copy has been given.
Yes, ma'am.
And para 39, you are placing from KD Sharma.
KD Sharma. Now, my lord, 16 is this judgment, my lord. Next slide. It is necessary for us to state here that in order to check multiplicity of proceedings pertaining to the same subject matter, and more importantly, to stop menace of soliciting inconsistent orders through judicial forums by suppressing material facts, either by remaining silent or making misleading statements in the pleading in order to escape the liability of
One second, sir. Either
remaining silent.
Suppressing material facts. Either by remaining silent or misleading. Yes.
Making misleading statements in the pleadings. In order to escape the liability of making a false statement, we are of the view that parties have to disclose the details of all legal proceedings and litigations either past or present concerning any part of the subject matter of the dispute which is within their knowledge. In case, according to the parties to the dispute, no legal proceedings or court litigation was or is pending, they have to mandatorily state so in their pleadings in order to resolve the dispute between the parties in accordance with law. Now, my lord, here the court has held past pleadings, if it is on similar cause of action between the parties, it has to be disclosed. And if there is no pleading, that also has to be disclosed. So my case here, my lord, they have failed to do so. Completely remained silent so that the court, why have they done so, my lord? That also have come up. I will substantiate, my lord. Because in the instant case, since the appellants had not disclosed the filing of the suit and its dismissal, and also the dismissal of the appeal against the judgment of the civil court, the appellants have to be non-suited on the ground of suppression of material facts. They have to come to the court with clean hands, and they have also abused the process of law. Therefore, they cannot be entitled for extraordinary, equitable, and discretionary relief. My lord, this is the recent judgment, my lord. 8 December 2021, Honorable Supreme Court has passed on this subject matter, my lord.
Thank you.
So, my lord, my submissions with respect to the suppression of material facts and with respect to not coming with clean hands, my lord, I have relied these judgments, my lord. In the background, my lord is well aware of the judgment passed in 8 V. Papaya Shastri and others versus government of Andhra Pradesh.
Which
wherein
one?
fraud has been discussed, my lord.
Next judgment.
No, my lord, I'm not relying on that. That's a principle which is already reiterated in all the judgments, my lord.
Show me the next one.
Yes, my lord. Now, my lord, the next, my lord, before that, my lord, takes up my list of dates, my lord.
Again on facts.
My lord, one point, my lord, because now I'm going to a next point, my lord, that there is no illegality. My lord, that says
This is your application for dismissal
Dismissal.
of writ petition.
yes, my lord.
How can you appear? How can you argue on the merit?
Not on merits, my lord. Prima facie.
Prima facie.
Prima facie, there is no
If the
illegal-
writ petition is considered, then
misconceived, my lord. My case is that the mid petitioner is misleading the court even on interpretation of law.
that's not at this stage. Then it requires an affidavit.
My lord, not on affidavit, my lord. Interpretation of law.
No,
It's from the same plane.
interpretation will come by placing the facts in the light of the law.
My lord, just their
All right, you make
just
it
their
sufficient.
pleadings, my lord.
All right.
My lord, kindly see.
Yes.
My lord, the second page, 19/2023.
Yes.
Environmental clearance was granted to the applicant by the prescribed authority, that is State Environment Impact Assessment Authority. My lord, date is very vital, my lord, and 13/9/2023. Thereafter, West Bengal Pollution Board issued a consent to establish to the applicant.
Which date that?
13/9/2020.
The West Bengal Pollution Control Board issued consent to establishment. When the writ petition was filed?
My lord, present writ petition.
Previous
writ petition was filed on, my lord, 28 June 2023.
20th June.
First date, my lord.
Online. First writ petition.
But disposed of, my lord,
On disposal is not matter.
28/6/2023.
28/6.
6
2023.
23.
So when first writ petition was filed, this consent to establish was not
Not
there.
there. When the writ petition was pending, it was.
Then
Thereafter, my lord, on 20/11/2023, the Honorable Court disposed of the writ petition being 1374.
so this consent to establish
Came
was
before.
in favor of your client. When the first writ petition was pending.
Pending.
So
It was
first writ petition when filed, it was not there.
not there.
All right.
They had challenged my recommendations for granting such things, my lord. My recommendations to get that environmental clearance was challenged in that said writ petition, my lord. Now, my lord, in that writ petition, my lord, I was a party, and my lord, the writ petition was running ex parte against. If any order had been passed, it would be against me also, my lord. It is not that I was not considered, my lord.
No, but in the order specifically takes one name.
My lord,
One of the respondents' name.
Yes, my lord.
And then the entire order went on that basis.
But my lord, my lord, when it was dealing, my lord, the court was considering the position of law also, my lord. In that judgment is also I am relying on, because why they have not disclosed is why it is material also, my lord, because the point they are raising in this writ petition is substantially decided by the honorable court. The same point. Now, my lord, their case here is that I have violated the biomedical waste.
Up to the, let's not go into those. Till the time consent to establish was not there, they filed a writ petition.
Yes, madam.
Challenging the previous steps.
Yes, madam.
Followed by which consent to establish came. Correct?
Yes, madam.
So all those stages they have filed. When a writ petition was disposed of against another, basically the orders were passed against another.
No, my lord, I would differ on that also, my lord, because the orders was passed with respect to the writ petition, my lord. My lord, what court has found that their interpretation of law, that the 75-kilometer radius, no other common biomedical waste treatment facility can be
Sir,
set
the
up.
moment you will be entering into all this, the moment it calls for affidavit.
No, I'm just trying to show what the separation and how it will prejudice me.
Yes, you
That
show,
is what I'm trying to show.
you show me that pendency of the previous writ petition, which is suppressed, how it will affect your right.
Yes, my lord, I am saying that, my lord. On that point only I am coming. My lord, that writ petition has adjudicated the facts and also clarified the position of law, my lord. Because that is an order passed by the Honorable High Court, my lord. If a coordinated bench passes an order on the same point, my lord, I would rely as in precedent for that, my lord. That court has not said that the position of law involved in that writ petition is whether there is any restriction of 75 kilometers for setting up a CM1 common biomedical waste treatment facility, my lord. This was the question raised before the court in that writ petition. If I just separate the facts and the law that was to be decided, the point of law there was whether...
Where is that order?
My lord, that order is in the application, my lord.
In your application?
In my application.
The disposal order?
Disposal order.
Sure. Dekhi?
My lord, it starts from...
Acha, you will make your submissions on that order also?
Yes, ma'am.
All right. Then at that point of time...
I was going to that order only, my lord.
Now?
Yes.
Okay. So...
My lord, if my lord takes...
No, wait.
29 it is starting, my lord, of my application.
এই অ্যাপ্লিকেশনটা কোথায়? অ্যাপ্লিকেশন আছে আলাদা?
My lord, may I submit a copy of it?
No, first let me find out. অ্যাপ্লিকেশনটা কোথায়? দেখে তো বল। So in the meantime, you place the reliance on your last judgment? Justice Sinha, SB Sinha?
My lord, in Bhanu.
You have referred to in your note, the last judgment.
Yes, my lord, Bhanu Kumar Jain.
Bhanu Kumar Jain.
Yes, my lord, that point after this judgment, it would be relevant.
Achha.
Because it's on constructive res judicata, my lord.
Yes, which page?
My lord, the question that the petitioner had raised.
19. Order starts at?
Order status pay 29, my lord.
এটাকে ঠিক করো তো একটু, এদিকে এসো, এইটাকে একদম এইখানে দাও। না না, ওটা না, ওটা না, দাঁড়াও, হ্যাঁ এটাকে নাও, নিয়ে একদম শেষে দাও। হ্যাঁ। Order dated
2011-2023.
please.
Yes, madam.
Yeah, I'm coming within 5 minutes, then you please. I'm just going and coming within 5 minutes. ওই অর্ডার গুলো পাঠিয়ে দিয়েছেন তো দেবাশিসকে? Coming. Yes. Show me from the order. Yes. রেখে দিন। ওটাও একটা সাদা ফাইলে গুছিয়ে রাখুন, ওখানে তুলতে হবে না, এখানে রাখুন, তারপর নিয়ে নেবো। আলাদা আলাদা দেবেন এগুলো। Yes. Show me, place it, place it. আচ্ছা, very well. রিটটা আমায় দিন। Internal page. Let's see. First, what was the challenge?
Error number 2.
You were respondent number?
First line.
None appears. So you did not appear. You chose not to appear.
You're not aware of the matter.
This nothing here. So the moment it ran ex parte against you, can you take the plea?
I'm not on that. It's a question that is raised, not
No, no.
against me or anybody.
No. Question that is raised. You have not opposed.
Point of law, my lord.
All right.
Whether.
All right.
What is the question, my lord, they are trying to say is there is a.
None appears on behalf of 11. Dekhi, counts to. Yes. Now you place from the very beginning and then complete this order.
Your lordship
No. First to show me, please. First to show me from the facts, whatever is there. Show me from the order.
None appears for respondent number 11. As the parties are ready and affidavits have been exchanged, the matter is taken up for final hearing.
So you have filed your affidavit. You have not even filed your affidavit.
You're not aware that the matter was.
So the situation is, it was ex parte. You chose not to file affidavit. You chose not to be represented. So the matter went on ex parte. So no adjudication against you. The moment it is ex parte, I will see. We will there, yes. And now, in aid of an ex parte order already passed, after accepting the same, you are saying that the second writ is not maintainable.
Not on that.
On suppression.
Not on that. I'm saying the point that is raised in the present case has already been decided by the honorable court. This is the same.
Okay.
Sum and substance of the challenge is same. The
Okay.
point of law.
Okay. Let's see point of law. Yes, sir.
My lord, para 2, writ petition has been filed for a mandamus upon respondent numbers 1, 2, 3, and 4 to withdraw and or set aside. Recommendation granted to MS SNG Environment Solutions Private Limited, that is respondent number 10, who was authorized to set up a common biomedical waste facility at Calcutta.
So this is the honorable, the coordinate bench has taken cognizance. The law as it stands. The law as it now, let's come to the question of law. The law is to what extent the coordinate bench has considered the writ petition. Correct? As would be evident from the judgment. So if you apply that law, it says it is a case against MS SNG Environment, respondent number 10. Read on, read again.
The petition has been filed for a mandamus upon respondent numbers 1, 2, 3, and 4.
They are the statutory authorities. Forget
In
it.
my case, they are the same statutory.
Forget it. Now in this writ petition,
To withdraw, cancel, set aside recommendation granted to MS SNG Environmental Private. I'm not taking the judgment for the material suppression of that. For that, I'm saying this judgment is a law that is decided.
throughout your case was material suppression.
I'm saying material suppression. Second point, man. I have completed my argument for material.
No, sir. Very well.
Now I'm coming to the different point, my lord, res judicata. I have
Very
raised that the matter is substantially decided by the honorable court.
Yes, and
The
and
same
res judicata, it's a question, mixed question of law and fact.
point.
All right. Yes, sir. Res judicata. Yes.
According
Please.
to the petition, the said recommendation by the government and the consent to operate by the West Bengal Commission was contrary to biomedical waste
So here two things were there. Recommendation
and consent.
and consent to operate, but not to you.
But
Read on. Read on.
they are saying, in this case,
Read on.
the provisions relied on the petitioner is Rule 7.3, Rule 7.4, and further reliance on the Central Pollution Control Board guideline, that is para 8A and 8A. These two provisions were relied to saying that the violation has been made under CFW. Now, my lord, it appears from the aforesaid provision or guideline that page that ACBWTF. My lord, it's not about me, it's not about any particular ACBWTF, which is located within a state or union territory, shall be allowed to cater to healthcare units at a radial distance of 75 km. However, in a coverage area where 10,000 beds are not available, with the radial distance of 75 kilometers, the existing CBWTF here in the locality may be allowed to cater to the healthcare units.
So who is the CBWTF here? In the light of this order?
In this case,
SNG?
but my lord, the proposition is for all the CBWTF because the
So
provision-
you say that a legal proposition decided naming a particular
and this is
individual.
In fact, there was a CBWTF who had made up of
CBWTF.
CBWTF.
You are also a CBWTF.
Yes.
So if it is decided against Ram, it will be decided against Sam. And res judicata will apply. Excellent.
CBWTF has set up within 75 kilometers. This is the subject matter.
Sir, come to the point of law. If the CBWTF being respondent number 10, being Ram, let's say, and you are Sham, respondent number 11. So the CBWTF has been whatever legality as if it is decided against Ram, it will be a res judicata against Sam.
Binding upon you also.
That's right.
Proposition.
So res judicata will operate against you also. That's your submission.
Party that
Absolutely, you're a party.
that I have violated 75.
Where is that? It is not the case before the learned judge.
My lord, this is the pleading with the repeat.
Maybe he has to be considered, but then has not been considered is a ground for appeal.
I will not press on this point. My lord. Now let this judgment be as.
No, you place on res judicata, no?
I'm not placing on this judgment. Let the judgment of the honorable court.
So you're sure you're not placing on res judicata? Rikun, Ashun. At the midst of submission, making his submissions, Mr. Ajay Singhal, learned counsel, has started his submissions on the point of res judicata to the effect that the judgment in the previous res judicata, the judgment dated November 20, 2023, in the previous res judicata writ petition, WPA number 1374 of 2023, though has been decided against one Messrs. SNG Environ Solutions in Environ
RON, Environ Solutions.
Enviro Solutions Private Limited, comma, the respondent number 10 in the previous writ petition. কি বললাম পড়ুন? In the midst of submissions. Enviro, ENVIRO SOLUTIONS. Private. Comma, the same would operate as res judicata against this writ petitioner, who was respondent number 11 in the previous writ petition. Poster. The fact remains, respondent number 11 neither filed its affidavit in opposition nor was represented in the previous writ petition when the said judgment dated November 20, 2023 was passed, comma, as submitted by Mr. Ajay Singhal, learned advocate, appearing for the writ petitioner hearing. Writ petitioner, appearing for the applicant hearing. Then he submits that then after making a substantial submissions on the point of res judicata, he submits that he shall not press the point of res judicata.
This judgment on the conduct.
He shall not press.
This judgment on the conduct. I think this as a point of law.
He shall not place reliance on the said judgment dated November 20, 2023 in support of his argument on the point of res judicata. What will you then? What should be your next submission? Tell me on this judgment. He shall only rely upon this judgment on the proposition of law it has laid down. Yes.
Before it was considering that the challenge was whether a CBWTF can be set up within 75 kilometers.
Not a CBWTF. Again, at the risk of repetition, I am saying, because you are repeating an argument without replying to the general proposition for this judgment cannot be relied upon, because you were a party to that proceeding. You were a party to that proceeding who chose not to be represented. Matter ends.
But law has been decided in, clarified in this.
In the facts of respondent number 10. So who knows that within 75 kilometers it is there or not in your this second writ petition? No, sir. No, sir. No, sir. Your saying will not do. It calls for an affidavit. Very well. Very well, very well. Very well. You proceed. Very well, very well. Very well, very well.
Last paragraph.
Yes.
The guideline. Because the challenge was that establishment of CPWTF within 75 kilometers of an existing CPWTF. This was the fact to that. And in the present case, the same fact. They are challenging no CPWTF can come up within 75 kilometers. The Honorable Court has cited this point, my lord, and said the guideline do not prohibit establishment of another operator for the purpose of removal of biomedical waste within 75 kilometer radius of the existing unit if the authorities are of the opinion that the capacity of the existing unit could not cater to more than 10,000 tons.
Existing unit means
The petition.
in this writ petition.
I am the second.
No. Read on. The guidelines do not prohibit establishment of another operator. So you have to read this in the light of SNJ or whatever.
Application.
You have to read it in the light of SNG environment.
What has reiterated, there is not mention of it's an operator, madam. There is a definition in the act of who is an operator.
All right.
It would be, madam, the guidelines do not prohibit establishment of another operator, madam, for the purpose of removal of biomedical waste within 75 kilometers. Their challenge is that I have set up a CPWTF within 75 kilometers, which is prohibited by guidelines. This is their case in the writ petition, and this judgment says there is no prohibition from in the guideline that says that 75 kilometers is prohibited for setting up another. So, my lord, let us look into the guidelines. I have also given the relevant provisions along with my short notes. In my relevant provisions.
Lordship.
So you are really arguing on the merits of the
Lordship, he is arguing on the merits.
You are asking.
From the case.
Very well.
Just their challenge, I am saying it is not tenable in law.
I don't mind, sir. I don't mind. I will deliver my judgment in my own way. You are taking the court into the merit of the writ petition. Very well. All right, you place. You place.
My lord, kindly take the relevant provision, my lord. That is given in the writ petition, my lord.
Which writ petition? Previous paragraph.
The guidelines is starting from page 59.
Page
59, the guidelines begin the biomedical waste management and handling goods.
Page 59 of the writ petition.
Onwards,
Page
61.
You have taken all these points in your note? You have written all these in your note? Thank you. Page 61.
Report the bottom M and N, two definitions. Five. 1062.
Yes.
I heard definition M, occupier.
M.
N. Page 61.
Yes.
Occupier means a person having administrative.
Where?
My lord, it means fourth last definition of the bottom. Occupier means can hand over a tenant.
Yes.
Occupier means a person having administrative control over the institution and the premises generating biomedical waste, which includes a hospital, nursing home, clinic, dispensary, and so on. And my lord, thereafter is N, operator of common biomedical waste treatment facility, my lord. There are two definitions provided by the rules, my lord. And this is significant in this case. An occupier and an operator has been distinguished. Now, my lord, they have relied upon Rule 7.
Who relied upon?
The petitioners in the writ petition that I have violated Rule 7, read with guideline.
Show me the relevant amendment from the writ petition.
My lord, para number 2, the petitioners are constrained to invoke extraordinary writ.
Wait. Para 2.
Yes, ma'am. At page 6 of the.
Yes.
The petitioners are constrained to invoke the extraordinary writ jurisdiction against the arbitrary action of the state and its instrumentalities and the Pollution Control Board in allowing CBWTF to be set up in violation of Biomedical Waste Management Rules 2016 and CPCB revised guidelines.
So where section rule
Thereafter, my lord.
Rule 7.
My lord, kindly takes 7.
Paragraph.
Para 7. Petitioners state that 3M, the rules 2006 being a person administrative, they have defined occupier.
Para 7.
Para 7. Then, my lord, para 8, they have defined operator. My lord, then relevant 10. The petitioners. My lord, thereafter, para 20.
20.
Yes. This is very important. The petitioners state that they
One second. Slowly. Go slow. Yes.
That
Read
the
on,
petitioner came to learn that a CBWTF, being respondent number 9, has submitted their application before State Environmental.
Unique is you.
Yes. Environmental Impact Assessment Authority created this for setting up a CBWTF. The petitioners have indicated that the radial distance of the proposed plant is this from the petitioners.
Radius, where?
My lord, after Jalpaiguri, West Bengal,
Petitioner have
indicated that the radial distance of the proposed plant, it should be plant, it's written plant, in 16.60 kilometers.
Plant, PLANT. Existing plant. Very well. Carry on.
From the petitioner's existing plant, and as such, they are in violation of the BMW rules 2016.
So they allege that it is within 16.6
kilometer and it is a violation.
So you show that
there is no restriction.
No, you show that it is not within 16.6.
No, my lord, I'm not saying that. There is no restriction to set up 2 plants within 75 kilometers. This is my case by law. So, my lord, again we go to the rules. Rule 7, my lord, what they have relied.
Rule 7, page?
Page number, my lord. It is at page 65 of the writ petition.
So your sole case is no restrictions to set up a plant within 75 kilometers.
Yes.
Right?
Yes.
And that is apparent from the rule.
Yes. The restriction is not upon an operator.
Show me.
My lord, a definition was there, operator and
Show me that
occupier.
75 first.
Rule
Which
7.3.
rule? Which rule, sir?
Rule 7.3 at page 65.
Rule 7.3.
Yes, ma'am.
Rule 7.
Yes, my lord. Treatment and disposal. One is
Why,
biomedical.
where?
Page 65, my lord. Top.
Treatment and disposal. Wait. Yes, sir.
My lord, kindly takes one. Biomedical waste shall be treated and disposed of in accordance with the Schedule 1 and the compliance of the standards provided
In compliance.
with the standards provided
Slowly.
in Schedule 2 by the healthcare facilities and common biomedical treatment facility. 2 is, my lord, occupier shall hand over the segregated waste as per Schedule 1 to common biomedical waste treatment facility for treatment, processing and final disposal, provided that the lab and highly infectious biomedical waste shall be pre-treated by the equipment like autoclave or microwave. Thereafter, 3, my lord, no occupier shall establish on-site treatment and disposal facility if a service of common biomedical waste treatment facility is available at a distance of 75 kilometers. My lord, an occupier has been restricted to establish an on-site treatment facility if there is a CBWTF within 75-kilometer radius. This is what the rule says, my lord. It's not upon an operator, my lord.
7.3.
It's upon an occupier. That is the healthcare facility, my lord.
So who are you?
I'm an operator of a common waste biomedical treatment facility, my lord. As per definitions, my lord, again, if we go, my lord, operator means person who owns and control a common...
Wait. Operator means a person having administrative control.
That is occupier, my lord.
Please. Occupier. Let me read occupier. I need a legible copy of
My lord,
this.
in the writ petition which I have given, there also it is annexed, my lord, which can I relight from that?
Yes.
The present copy which I had given, my lord.
Should my learned friend is relying on the application?
Page.
My lord, in the previous writ petition, the enactments were at relevant at page 60, my lord.
60.
Yes, sir. 61.
Wait.
Biomedical waste.
Which page?
My lord, 61, there are 2 definitions, my lord.
Then 7.3.
7.3, my lord, it is at page 65.
Kindly come to page 61.
Yes, my lord.
Take M.
N, operator of common biometric.
Occupier. M.
M,
Madurai.
occupier.
Madras.
Yes, my lord. Means,
Under which category you come?
my lord, I am N.
So you are not an occupier.
No, I am an operator.
Operator of a common Madam, do you admit that the applicant is an operator or occupier? Which one you admit?
Lordship, the Biomedical Waste Management Rules 2016, 3M and N defines occupier, and thereafter the definition of operator comes. Now the respondent number 9 is an operator. What is an operator, your lordship? One who operates a plant. And occupier, the definition provides, occupier is the healthcare facilities, including the health department, who decides on establishing of such operators. Lordship, when I am allowed to make my submission, your lordship, I'll clarify. My learned friend has now entered into the merits of the matter. Lordship, the case is very simple. It is the operator who is to operate at one point. Lordship, if I may explain in this manner, suppose I am at Jalpaiguri. So my plant is as Jalpaiguri, and I cover an entire radial distance of 75 kilometers from where my plant is. So I am establishing a plant. This is a hazardous plant. This 2016.
So you are an occupier.
I am an operator. I am also an operator. He is also an operator.
He is also an operator.
He is also an operator. My learned friend throughout is making submissions, your lordship, which are not tenable. I am constrained to make the statement. Lordship, kindly do not take me amiss.
One second. Then who was SNG?
SNG is also an operator. We are all operators. We are the private concerns and health department and the hospitals.
So you are an operator.
Operator.
Petitioner is an operator.
Lordship.
SNG is also an operator.
Lordship.
Occupier is that entity which occupies a particular medical establishment.
Who generates
space. That is the medical establishment generating medical waste. It may be a hospital, it may be a nursing home, it may be a dispensary. These are occupiers. And the treatment is to be done by the operator. Treatment of the biomedical waste is to be done by the operator.
Okay. So from the occupier, operators collect.
Yes.
Operators takes it to in own plant.
Yes.
And then
reads it.
Never.
Within 48 hours, that is mandatory.
Lordship,
these three are all operators.
Yes,
all operators.
All operators.
3N. Definition of 3N.
Now let us come to that 75.
73.
Lordship, may I make one submission, your lordship? Since my learned friend, your lordship, I'm being hearing, since it has entered into the merits, your lordship. Lordship, the difficulty is that whatever he is pointing out, your lordship, these are all on merits. May I have the opportunity to explain over the same?
No, you will make your submissions.
Lordship.
Now, first I have now understood occupier and operator.
Lordship.
Because I am not a technical man. I have to go by the rules.
Lordship, then may I make, since my learned...
Come, please. Now come to Rule 7. Come to Rule 7.
Lordship, my learned friend will be placing Rule 7.
Yes, now read rules 7.3.
Lordship,
No
Lordship,
occupier.
may I place rule 7.3 or?
Yes, please paste it
Lordship.
from page 65 of the old writ petition,
Page
previous writ
65.
petition. 65 of the previous writ petition.
65.
It is legible there.
Lordship. Rule
3.
7.3. Biomedical waste treated and disposed of.
7.3. 7.3.
Yeah, it's a 7.
No occupier.
In case where
is
service
good.
of the common biomedical waste treatment.
That you are reading.
facilities-
You are reading 4. You are reading 4. Rule 3. Read
Rule
3.
7.3. No
Ah.
occupier shall establish on-site treatment and disposal facility if a service of a common biomedical waste treatment facility is available at a distance of 75 kilometers. Now, Your Lordship, let me clarify. Now, Your Lordship is aware what is the duty of an occupier. My learned friend is throughout trying to explain who is an occupier and who is an operator. Very well. Let us go by his definition. His definition of occupier means the healthcare facilities. Now, I'll once again take Your Lordships to the definition 3M. He can be immensely tactful, but maybe he's traveling beyond records. Coming back to the definition of occupier, reading in alliance with page 65. An occupier shall establish. Now, what is an occupier? Occupier at page 61, 3M, means a person having administrative control. So, a hospital doesn't have an administrative control. It includes the health department. He is aware, but he is not placing that. The health department, when it finds that already there is one within 75 kilometers.
Suppose if it is of a private hospital.
Lordship, for private hospital, there are private agreements. My learned friend is throughout suppressing. Private hospital, private agreements. This entire rules has to be followed by the government bodies. We are solely covered under Rule 2016. Occupier, let my learned friend deny that health department is not an occupier. Let him deny that. Lordship, may kindly records. Let him deny. I'll make my submission in that line only. Misleading the court has to be also a limit.
Who is the ultimate authority to decide?
Yes, Your Lordship. The ultimate authority is the health department. Who is deciding?
Who will have to decide? The health secretary.
Lordship, I'll come to that. The health department is the primary authority who decides that these are the hospitals.
No, I am thinking in a different way.
Lordship, may kindly put across the what has fallen from your Lordship. I
Yes.
think I'll be able to answer.
If both of you I sent before an authority,
Lordship,
who shall decide this issue in the light of the pending writ petition?
it is the health department along with pollution control board along with the SEAC committee. What are the functions? Totally laid down in 2016 rules read with the guidelines that once it is decided the requirement in an area, minimum 10,000 beds has to be.
No, because this now comes the geometry to play. This 75 kilometer, who will be within 75, whether all three of you are 75, because I will not take SNG in the picture. Because against SNG it is decided.
SNG has suffered a termination order.
That's right. So it is decided.
It is decided. SNG has
So
suffered
if I send your client
Lordship
and the respondent number 11,
Lordship,
whatever, 9, the applicant and your client, who shall be heard by an authority and he shall decide the issue.
it should be the secretary of the health department along with the chairman of the pollution control board. And Lordship, if I may be allowed to make one submission out of my way, there should be an independent body.
No, who is the higher in the authority? Health secretary.
Should be, Lordship, it should be the IS officer.
Health
And
secretary.
the chairman also is an IS officer. Now, Lordship, the
Who will have to
difficulty.
decide it? Who shall decide this? Because this is now gradually it comes to complications on facts.
Lordship, absolutely not. Lordship has not heard me.
No.
Lordship has given him, I think, on the last day and today almost 2 hours. Lordship
Alright.
hears me only
Yes,
for
I
half
will
an
hear
hour.
you. I will hear you. Be
Lordship,
rest assured.
Lordship
But the
kindly hears
thing
me
is
today half an hour.
Yes, I will hear you, madam. But can it be done like this?
Lordship, it can be. It can be.
That both of you, if are sent before an authority, before whom all these things will be taken care of.
Lordship. An
they shall
independent
pass it.
authority also can do the same. Lordship keeps the writ petition pending, sent us before an independent authority along with the secretary to be a part of it. Lordship kindly hears me after the, if your Lordship is taking up after the recess, kindly hears me only for half an hour. I will not take more than half an hour.
No, I am absolutely eager to hear you. Don't worry about it.
Lordship.
Don't worry about it. Why shouldn't I? But the thing is, I want to come to a solution to this.
Lordship, perhaps today your Lordship may also.
No, because I tell you, this is such a technical issue. Even on affidavits, how far on the first hand?
I'm grateful, my lord. Your Lordship decides it today. Let us go before an authority with the observation of this honorable court.
No, I will simply say that applicant will be present, you will be present.
But Lordship, the suppression of material facts,
those I will make it clear. I will make it clear. I will say it will have to be decided on merit. Why I will give my reason.
Lordship, because till now, subject to corrections by this honorable court, the case he has tried to make out, suppression of material facts, not a single material fact he has placed before the honorable court.
I will, sir, madam, I will make my observations on the application.
Grateful, my lord.
I will hear you. I will also hear him and make my observations on the application.
Grateful, my lord.
And then I will send it back, send it to the authority.
Authority keeping the repetition pending.
Of course, because authority cannot take a call on decide the point of res judicata or not. Suppression of material facts or not.
Maybe they can also.
That the authority cannot take.
Maybe
authority will have to adjudge in the light of the prevailing rules.
I am grateful, my lord. They are
all right. I will hear you.
The rules.
I will hear you.
Lordship. Let me come back here, Lordship.
Achha. In presence, the pollution control board will also be represented.
Lordship. Let them come.
Achha. Now during this recess, you take your instruction, if any, or you consider what the learned state advocate is saying.
Lordship.
That if this entire thing can be, after deciding the application, if the core issue can be sent before the health secretary, principal secretary health, who shall give a hearing to you, the applicant, and the appropriate authority of the pollution control board.
Lordship, now here I am aggrieved by the order of the principal secretary. My learned friend has not yet allowed me to enter into the merits.
Now, 1 second. Then the health secretary.
Independent authority. I'm not aggrieved.
Health secretary is below the principal secretary. Then the chief secretary.
Lordship, an independent authority. Your Lordship sends me anywhere. But he should be independent.
Who can be an independent authority? I have no idea. Tell me.
Lordship, I'll come up after the recess here, Lordship.
No, but if the impugned order is passed by the principal secretary, I cannot send it to the principal secretary. He cannot be the judge of his own cause.
Lordship.
A specific provision of appeal, the allegation that they are challenged, environment fear.
Now you listen to this point.
Lordship, my learned friend is not audible.
He is saying your writ is not maintainable because the appellate forum is there.
Lordship kindly decides on that. I'll also argue on that.
Specific appellate clause for this particular challenge, my lord.
My learned friend has made many submissions. Lordship, I'll answer to that. Let him come up with the appellate forum.
My lord,
whether a government order, can I go before an appellate forum or I have my jurisdiction within 226?
No.
And if that is so,
Very well, I will read the appellate provision.
in his scan, he has not taken that point.
I will read the appellate provision and I will hear you also on
Lordship,
that.
that
You will make
at
your
the
submission.
at the very first, we'll place on the rules.
I will be more keen to hear you on first on appellate jurisdiction, right?
Lordship.
And secondly, because material suppression, this, that will come later.
Lordship.
I will hear you on that. That will be later. But I have to hear you on alternative remedy of appeal. And then who shall be the authority if
Lordship,
I...
then my learned friend, since it is his point, there is an alternative remedy. Let him also place the relevant section. Let him place it.
I will. He will.
Since he is raising the point, Lordship, I am sticking to my submission. There is no appellate forum when the order under challenge is passed by the principals, the secretary in the rank of the health department. We are aggrieved by that.
All right, I will hear you.
Lordship.
After at 2 o'clock.
Grateful, my lord.
করে আসবেন মানে পাস হয় আরেকটা
Yes. Show me that appellate provision.
My lord, I have given the National Green Tribunals Act, my lord. Section 16. (16H).
Yes.
My lord, 16 reads, any person aggrieved by H, an order made on or after the commencement of the National Green Tribunal Act 2010, granting environment clearance in the area in which any industries, operation or process or class of industries, operation or process shall not be carried out or shall be carried out subject to certain safeguards under the Environment Protection Act 1986. My lord, in the present prayer, my lord, they have challenged this.
Order made on or after commencement of National Green Tribunal.
Granting environment clearance.
Wait.
Rahul.
All right. Yes. Yes.
My lord, the prayers they are seeking, my lord, is to cancel, set aside the environmental clearance granted, my lords. My lord, the specific provision, my lord, there is a specific appellate authority, my lord, constituted, my lord. So that, my lord, this writ should not be entertained.
Okay. So why this point was not taken at the threshold?
Lord, it was my difficulty, my lord. I was not prepared on the last date, my lord. That was the only reason. Going through the entire.
In your application, you have stated.
No.
But it's a point of law, my lord, which I ought to indicate to the court.
National education.
Good. This is when my lord placed that Order 7, Rule 11 principle, my lord, this falls under the clause D, barred by law.
But it has to be stated.
It has to be stated, my lord, but this is a point of law, my lord. Nothing facts is to be added, my lord. Their writ petition prayers are completely.
All right, next.
This is my case, my lord, thereafter, my lord. Nothing else on my part. Not maintainable on view of these 4 grounds, my lord. I have all placed in my short notes also.
You have taken this alternative remedy point in your notes.
Short notes, yes.
You have taken?
Yes.
Show me.
My lord, last para 6 of my notes, my lord.
Yes.
Second last page in bond.
Para 6.
Para 6.
Where?
The writ is not maintainable on the ground.
Where? Para 6 I can't get. Watch a 6.
Has failed to invoke the jurisdiction of appropriate tribunal constituted under the statute and has approached the writ court even though an alternate effective remedy is available under law. The writ petitioner has challenged this order of granting environmental clearance. It would be pertinent to section 14 and 16 of it. This is my case, my lord. These are the grounds I have placed reliance, my lord, that the writ is not maintainable and it should be dismissed, my lord.
Yes.
Lordship, then
Madam.
Lordship has directed me to address first on the point of maintainability, which my learned friend has now taken in his short notes. Lordship, now may I indicate? Lordship, on the last date, very categorically mentioned that the short
Today
note.
you have placed your judgments.
Yes, ma'am.
Yeah? Oh, that is in the note.
Note. And the 2 judgments at relied on.
সেটা আছে.
That in the short notes submitted today, if your lordship remembers, your lordship, on the last date, that he shall not take any new point other than his CAN application.
Yes, what new point they have taken?
Lordship, this new point which my learned friend has now stated on the point of maintainability.
That's a point of law, jurisdiction.
Lordship, then lordship, even if I'm only stating what has fallen from this honorable court, but still I'll answer.
Yes, you answered the appellability first.
Lordship, I'll first answer to that. Now, NGT, the National Green Tribunal Act, Section 16H, which provides an order made on or after commencement of the National Green Tribunal Act 2010, granting environment clearance in the area which any industry operation or process or class of industry process shall be carried out subject to certain safeguards under the Environment Protection Act 1986. Lordship, thereafter my learned friend has referred to any other section, your lordship. I could not hear him, your lordship.
No. 16H.
Lordship.
16H.
Now, lordship, this act refers to the provisions where under the environment clearance is issued. Does these provisions provide that challenging an environment clearance, I have to only prefer an application before the National Green Tribunal? Has my learned friend been able to show that provision? What my learned friend has now taken a new point. That is, I have an alternate remedy. Your lordship, we have learned from your lordships that even if there is an alternate remedy exists, I am not debarred from approaching before Article 226. I will not even go to that. That is on a much higher aspect. This is a provision which provides a consent to establish the environment clearance in which provision can be issued. My learned friend is not pointing out there is alternate appellate authority, alternate remedy, then my learned friend has to indicate. Lordship, I am constrained today to make this submission, your lordship. I may be taken amiss. From the last date till today, entire submission made has no basis at all. And today he rests his submission that I undertake to withdraw the point of res judicata. He has not even dealt with my reply to the application when I have specifically stated what is res judicata. Res judicata point he has taken up today. From the last date, his only submission was, I have preferred one writ petition 1374. How that writ petition has culminated and clubbed inside this writ petition. Till now, he has only stated how in that writ petition an order was passed. May I make my submission on Can 1? Lordship. Now the Can 1, which was my learner's friend's case.
You are making your submission in
Lordship,
that application.
I was making my submission first with regard to the NGT Act. Lordship, with regard to the NGT Act.
NGT Act, you show me that 16H is not applicable. First, you show me that.
16H is only applicable with regard to issue of environment clearance.
No, kindly see. An order made on or after commencement of such and such, granting environmental clearance.
My lord.
Is this not consent to operate?
No. Environment clearance is given. Thereafter, when the plant is established, then only a consent to operate can be given. Now, in this case, particularly in their case, they were in such a rush, including the deputy secretary. The secretary rank have obtained instruction that before the plant was established, they have obtained the consent to operate. How? On 3rd March, the matter was taken up. My learned friend chose not to appear, despite service. This time, he cannot deny that he was not served. 3rd, the matter appeared. He did not appear. On 6th, immediately the consent to operate was issued. If a case has to be made out of unclean hands, then I have a better case than my learned friend.
No, okay. Now you first tell me,
Lordship,
that whatever you first submit on that his submissions after he withdrew the point of res judicata.
Lordship,
After he withdrew the point of res judicata, his points are only on suppression, material facts.
Lordship, I'll also answer to that.
Right?
Lordship.
His submissions will remain only in respect of suppression of material facts.
Lordship.
Right?
Lordship.
So after he withdrew his issue of res judicata, you make your submissions that it is not a suppression of material fact.
Lordship. Then I'll refer to his canon.
Which can?
Lordship, Can 1.
No, you have to refer to your writ petition.
Lordship, I'll be immediately coming to the writ petition. Can 1, since he has made an extensive argument on Can 1, it is his own
That is
point.
his application. That is his application.
That is his application. It is his own points. He has chose not to use a comprehensive affidavit, which is specifically directed in an order. And he has not made that I'm restraining myself from filing any affidavits. Lordship may also kindly record my submission since he has decided not to file any affidavit and he has not prayed for extension of filing affidavits. He should be debarred from the same. Lordship, in the order dated of...
Order dated?
Lordship, in the order dated...
So you say that consent to operate is not an appealable order.
Consent to operate, Lordship, no. It is the contents which has to be. Lordship, or the order dated, Lordship kindly sees the order dated 12th March 2025. The running page 3, paragraph 6.
12th March 2025.
2025.
Yes.
Lordship, last page, page 3, paragraph 6. Let comprehensive opposition be filed by PCB and respondent number 9 within 3 weeks from date. Lordship, today we are in September. Neither he has prayed for extension to file the affidavit.
Chose not to file any affidavit.
We challenge the maintainability first. We have taken out the can immediately.
Maintainability doesn't prevent him from filing a comprehensive affidavit.
If it's the WS, my lord, that clock stops. If
Yes,
I file the
WS, we
order
are going
7
back
rule
to
11,
suit.
I can file my WS after
Yes, after 90 days, if suit is so,
No,
if
that's
it's suit,
that is misleading, my lord. The clock stops when the
Yes.
maintainability is brought on.
All right.
my learned friend is referring to provision
All right.
for
Next,
suit.
next.
Lordship. Now can 1, it is his own submission, paragraph 4. Can 1.
Can 1.
Can 1. My learned friend's application on maintainability.
Yes.
Can 1, your lordship, paragraph 4. This is my submission from his application on material facts.
Yes.
Your petitioner number 9 states that the petitioners of the instant writ petition has filed a more or less similar writ petition being WPA such and such for issuance of a writ of mandamus against one SNG Enviro Solution, who was the private respondent number 10, and the present respondent number 9 was the respondent number such and such here. Now, it is if one is challenging on the point of material suppression. Perhaps my learned friend on the last 2 occasions has repeated 100 times, I have come with unclean hands. So if at all that is the submission, then his statement could have been filed a petition on absolutely similar grounds. It is more or less similar writ petition. That is, he is in doubt. He himself is in doubt with regard to the contentions, because he is well aware that 1374 was passed solely against SNG. SNG has contested, and the cost part, which was also tried to prejudice this honorable court, was that I had obtained an interim order. The interim order was not obtained under material suppression. The suppression was that the service was completed upon SNG or upon present respondent number 9. What has happened? The item showed dispatched, but it was not delivered by the time the interim order was passed. That was the reason why I was saddled with a cost. When I had traveled to the honorable division bench, it was considered that it was not a mistake on my part. It was the postal records which could not be obtained at that very moment. Now there is another submission to that. This respondent number 9 was very bold with the submissions today. He kept on changing his address so that the service cannot be affected on him. And he deliberately...
These are neither here nor there, madam.
Lordship, it is here because he did not appear in 1374.
You submit on the merit of Can 1.
I will. He did not. I'm submitting on the merit.
This is no merit. This
Lordship
is no merit. I will not go swayed away by those. You submit on substantive points in Can 1 that material suppression is not there.
Lordship. Now, the Can 1 solely refers to the writ petition of 1374.
And the order passed.
And the order passed.
So better you make your submissions on that.
I am only restricting myself to 1374 and the order. Now, 1374 was a writ petition at the stage of recommendation. That is the one submission on the merits of the matter. Now, in 1374, my prayer was...
Hey, order ta kothay gelo?
1374
order disposing 1374 is annexed to your application. It's annexed to your application at page 29.
That's 29.
Fair enough. Yes, madam.
1374, the first prayer is that to set aside...
One second, madam.
Lordship.
This is 1374.
13, the earlier writ.
Yes, madam. Place it.
Lordship,
1374.
page 51. My prayer.
Yes, madam. Prayers.
Prayer, Roman 1, page 51.
Yes.
Now, prayer 1 is to set aside the recommendation granted to MS SNG Enviro Solutions Private Limited. This is prayer 1.
Yes.
Lordship, the next page, page 2. Prayer 2.
Yes.
To set aside any recommendation granted to Unique Universal Bio Waste LLP. So here comes the respondent number 9.
Unique is your client.
Unique.
Okay.
Respondent number 9. Now coming to the
Yes, then.
now, your Lordship, coming to the writ petition.
Yes. Then.
Page 9.
Fine.
Para 7.
Yes.
Rule 3M of the said rules defines occupier. Means a person having administrative control over the institution. That means and clarifies that occupier includes all the government hospitals.
The petitioner.
Para 7.
Para
Page
7.
9. Page 9.
Read on.
Rule 3M of the Rules 2006 defines occupier. Having administrative control over the institution, that is the government hospitals, because all the government tenders will find only in respect of the government hospitals, not private. And the premises generating the biomedical waste. And herein, the Department of Health is the occupier. I'm pausing here for a moment. My learned friend, in his extensive submission, nowhere denied, since he's referring to 1374 extensively, that health department is not the occupier. He has not denied. Lordship.
No, there he has not filed any affidavit. He was not represented.
He has chosen not to. There and here. Both were. He is not.
Absolutely. They chose not to file.
Chose not to file.
Very well.
Next, Lordship, coming to 3N, next para, operator.
But madam, again, these are all
on merits.
On merits and have to be decided on affidavit.
Lordship
You first show me their application after they withdrew the point of res judicata. After they withdrew the point of res judicata, their application stands only on material suppression of fact.
Actually, I'm coming to that. If I do not place the material, these facts, what is the material suppression? That order passed in 1374 has affected them here. If that is their submission, your Lordship, then I will only restrict there. The order of 1374 has also affected them in present writ petition 443. Lordship. Lordship, I'm only on that. I'll be very precise. I'm only defining occupier operator. Now, the respondent number 9, SNG and I, we three are operators now. Who is an operator? A common biomedical waste means a person who owns or controls a common biomedical waste treatment facility for the collection, such and such handling of biomedical waste. That means an operator is one coming within the definition the moment he owns the same, not till the stage he has not established. When I had come under the present writ application, the respondent number 9 was not even having his plant. He was not even an operator, but still a consent to operate was issued. When is a consent to operate issued? when he has already established the plant. That he will not state. He has come with absolutely unclean hands while he was not stating material suppression. What is the material suppression? The
Acha,
material.
madam, you first, so according to you, first consent to operate has to come, then
No,
establishment.
Lordship, the first, it is the gap analysis. One plant is existing, the another plant is to become, has to be set up. What is there? The rules say the Pollution Control Board, along with the authorities as required under Schedule 1 and such, everything is extensively given. They will conduct a gap analysis, the distance between one to the other. Then the provision of gap analysis is not required if at 2 kilometers each a plant can be established. Once the gap is analyzed, a report is submitted. Now, there is one point which has to be thought in propos of the rules and otherwise. The rules have come out from the Environment Protection Act. Why? Because a requirement was felt for segregating the normal waste with the biomedical waste. Why? Because it was found that the biomedical waste are hazardous. So one cannot under any circumstances choose to have every plant in every point. It has to be very restricted because the incinerator is run, autoclave is run, and it emits emissions which is not good for the humans, which is not good for the environment. That was the reason of restricting to one.
No, that's all right. All right.
Now his material suppression, whether in the present writ petition 443, whether I have suppressed that he has already his recommendation was dealt with in writ petition 1374, my answer is no. There is no suppression. Now, gap analysis stage was given a complete go by. Recommendation stage was again given a complete go by. Now, when I am coming, the writ petition was disposed of on November 2023. November 2023. By then, your Lordship kindly sees this consent to operate. Lordship may now very kindly takes my present writ petition.
Show me the consent to operate you have annexed.
Lordship, yes.
Page.
Lordship.
Dated.
Lordship, kindly grants me a moment. September 2023, page 157.
1 second. 13 September 2023. Consent to operate.
Lordship, I apologize. Lordship, the consent to operate was granted on 6th March.
Where do I get?
That is in the supplementary affidavit.
6th March? 6th March?
6th March.
2020?
2020. Lordship. In the supplementary affidavit, it is stated.
Date.
6th March 2025. Supplementary to that.
Page.
Lordship, I'm on the supplementary affidavit.
Correct.
Lordship,
Page.
I am coming. Lordship, page is page 90. 919.
Okay.
Page 19 and page 11 and page 90.
Why two?
Lordship, there are two consent to operate. Lordship, kindly take the supplementary affidavit.
I will
which
take,
is
but
affirmed on.
Before that, let me see your prayers in the writ petition.
Lordship, 11th day of March 2025.
Yes.
The supplementary affidavit is affirmed on 11th March 2025.
One supplementary is there.
One, sir, that is mine.
That's right.
Lordship.
So page 11 and page 19.
Lordship.
Yes, page 11 I got.
Lordship.
Of March. 6th of March.
One is consent to operate.
What is 6th of March, page 11?
6th of March, page 11 is the consent to operate.
Right.
And Lordship thereafter.
And what is 19?
Lordship. 18th, 19th.
The authorization.
The authorization. Lordship, at the very first, form 3, it is authorization.
Authorization.
Lordship.
Now let us
Lordship.
see your prayers in the writ.
Lordship. That is at page, starting from page 52.
Read on.
Lordship.
Cancel and set aside the environment clearance.
Cancel and set aside to forthwith, immediately withdrawn, cancel environment clearance dated 1/9/2023 and consent to establish dated 13/9/2023.
So it
Granted
is
in
not
favor
why
of
13/9/2023, why not 6th of March 2023?
Lordship. Lordship, now thereafter, kindly takes up.
Where is 6th of March you have challenged?
Lordship, in the supplementary.
Supplementary, there cannot be any challenge.
Lordship,
Unless
this
you
is
amend your writ petition.
Lordship, I'm explaining over.
Where is your challenge? 6th of March?
6th of March, Your Lordship. Lordship, prior to that, the writ petition, Lordship may very kindly takes.
Madam, you show me your challenge to 6th of March.
Lordship.
If you have not challenged 6th of March, it remains. Where is your challenge to 6th of March? If you have not challenged your 6th of March, it remains. Show me from your writ petition.
The writ, Lordship, 6th of March.
Suppose tomorrow.
It has come up, Lordship.
Suppose tomorrow your writ petition is allowed.
Lordship.
What relief you will get?
Lordship, his consent to operate and the same goes.
No. Come on. Be specific, madam. Show me the prayers and show me the dates and all. Be specific.
Lordship.
Suppose tomorrow this writ petition is allowed. What will happen?
Lordship. Then your Lordship kindly takes the writ petition, page 28. Lordship kindly takes this. Page 28 to 29. They have suffered a rejection order. That was my case.
Page 28.
Page 28 of the writ petition.
Yes.
Page 28, the Lordship has taken.
Yes.
Para 42.
Yes.
States that without the gap analysis, the respondent number 9 was allowed to submit TOR, and in subsequent steps, it was allowed to participate. That despite not fulfilling the distance criteria, the consent to establish was approved in favor of the respondent number 9 on 30th September 2023. So, it is the consent to establish was approved. And
Madam,
March, it was granted.
So I have a very specific question.
I'll immediately answer. It is answered in para 44. I'll immediately answer.
Yes.
Next page, Your Lordship. Page 29, paragraph 43.
Yes.
The EC was also granted by SEIAA in favor of the respondent number 9 in violation of rules 2016. Now next part. The petitioner states that respondent number 9 has not set up a CVWTF but had applied before the West Bengal Pollution Control Board for issuing the consent to operate in favor of the respondent number 9. This is my grievance, that the WBPCB rejected such application on 31st December 2024.
That this is has to be decided on affidavit.
Lordship, it should have been decided.
It should have been decided on affidavit, both from State Pollution Control Board and the respondent number 9.
Lordship, I bow down to that. But Lordship, the difficulty is that when the matter.
11. So you have nothing to do. You enjoy the fruit of it. Absolutely. So yes, you enjoy the fruit of it. It's really between the two, respondent number 9 and the petitioner. Yes.
Now, Your Lordship, there we are agreed.
So, Madam, again, perhaps we are digressing from the main issue in the application.
Lordship. Material suppression.
Yes. His ground is writ petition should be dismissed in limine on material suppression. Whatever you have prayed, you have not prayed, will come later.
The suppression is that an order which has been passed
and the writ petition and the
at that point of time is affecting him here, and by dint of that should have been indicated here.
Absolutely.
Now, materials point is only one.
Yes.
That was at the stage of recommendation. Point 1. Point 2 is the order was passed solely and wholly against SNG Enviro Solutions and nowhere it was dealt with respect to the respondent number 9. Second submission. Third, in the present writ application, the challenge is that such consent to operate was rejected by the Pollution Control Board, which has occurred on 31st December 2024. It has no relevance with the dismissal of the writ petition in November 2023.
Right.
These points were not stated by my learned friend.
No, not only that. That stage had not arisen in the previous writ petition.
Lordship, so therefore,
this incidents of 31st December 2024 is a post disposal of first writ petition.
Lordship, I bow down to that.
That is what I said.
So therefore,
that is what I said.
Therefore,
that the day when consent to operate has become effective, the writ petition was decided before that.
Lordship. Not only that, consent to operate was effective after filing of the second writ petition. This is the crux of the matter, which I will now point out. It has not been issued. Lordship, it was not issued before even filing of the writ petition. It was approved. I had come at the stage when it was approved. And it was rejected.
When that first writ petition was decided?
On November 2023. The date is, Your Lordship, 20th November 2023.
One second. First writ petition was disposed of. Dated.
20th November 2023.
Correct.
2023. And the order of rejection of the consent to operate is on 31st December 2024.
This is a wrong submission.
Para 29. May my learned
Para
friend will have
44.
his para 44, page 29. I may make a wrong submission. Page 17 is on evidence. I'm not making submission of the record.
You submit that the statement in the petition is wrong. Huh?
From the affidavit of the petition.
Yeah, from you not even.
It's a very serious matter, my lord. They have
So
forced the
that-
document and
You should have filed an affidavit there too that it is a wrong submission. You have chosen not to file affidavit.
Grateful, my lord.
control board's document.
It doesn't matter. I will not hear them at this stage. It is between you and petitioner.
Yes.
So how do I take it? I have to take all the statements made in the writ petition to be correct when I am deciding your order 7 rule 11.
Grateful.
And from the statements made in the writ petition, you have to show me, I have to come to a conclusion that your application succeeds. Otherwise, your application will have no merit. This application. So if you say today that this statement is wrong, that West Bengal Pollution rejected the application on 31st December 2024, I will not take that submission. Because
I'll reserve that for the appropriate.
So if you reserve for your affidavit, then where is the utility?
I'm saying if it is required.
Yes.
Lordship. So therefore, your lordship, on the material suppression, I will not take 2 hours to answer to that. The order of 20th November is absolutely clear that herein the respondent, the SNG Enviro solution, this order was passed with regard to the CBWTF been established by SNG Enviro solution, and nowhere my learned friend has indicated that it has affected it even to the extent of 1%. And if your lordship so directs, I'll again read the entire order. But that will again waste the time of the honorable court.
All right. These
He
are
has
your
not pointed
submissions.
out.
These are your submissions.
With regard to material facts.
Absolutely. That is
What
the only
material facts?
allegation. Only allegation that stands in from his application today.
Lordship.
These are your submissions.
And lordship, since he has also made material suppression on merits with regard to rules, he has also
Madam, those are all at the to be taken care of at the stage of hearing.
Lordship, since he has made his
I am only on his application today.
Lordship, and now I'll only distinguish only one judgment. Now he has referred to few judgments.
Tell me the distinguishable point. Tell me.
Lordship, only one.
Because take it from me. That the legal principles which are decided in those judgments,
Lordship,
right? I have taken them. I am bound by them, and those are all correct legal propositions.
Lordship.
Those are all correct legal propositions.
Lordship.
So you make your submissions.
Lordship.
Very broadly, you have your answer in one sentence. I want that sentence if you make your submission. I accept those judgments because those are the principles of law laid down. They are universal.
I may not be able to understand what has fallen from your lordship with regard to
that you tell me, what do you want to say?
Lordship, with regard to material suppression, it is my learned friend, since it is the allegation that I have suppressed, the material suppression is on my part. The only point which perhaps, if I'm able to understand this honorable court, material suppression is one such fact which, if suppressed herein, has affected his rights in the present writ petition. With regard to that, none of his rights have been curtailed by suppressing the earlier writ petition in the present writ petition. That my learned friend has nowhere indicated. That can be the only case, because the meaning of material facts, that is, without disclosing of the same, the respondent or defendant shall suffer irreparable loss and injury. That he is not suffering. And that he could not.
All right.
The recommendation.
These are your submissions.
These are my submissions, and with regard to the judgment referred by my learned friend in Shri K. Jairam versus Bangalore Development Authority. Here,
Yeah.
paragraph 12, it is written, it is well settled that the jurisdiction exercised by Honorable High Court under Constitution of India is extraordinary, equitable and discretionary, and it is imperative that the petitioner approaching the writ court must come with clean hands and put forward all facts before the court without concealing or suppressing anything. Now, your lordship, this anything my learned friend has harped upon material facts. A litigant is bound to state all facts which are relevant to the litigation. So I have stated each and every fact which are relevant for the adjudication of the present litigation. I have not stated those facts which are irrelevant in the present writ application. And it is the case of the respondent who...
It is not. It again, the expression you used was never his case, neither is the answer. Irrelevant. Irrelevant or relevant is not the question. Question is whether it is material.
Material. So a litigant is bound to state all facts which are relevant to the litigation. So, and any irrelevant point.
You may say 1,000 irrelevant points, no issues.
Yes.
But
that
whether
one
the relevant one has been
there.
stated or not.
But that one relevant point has to be stated.
Yes.
What was the relevance? A recommendation granted to SNG, is it relevant for the respondent number 9? Is it relevant that the rules were decided with regard to the application of SNG? Whether that was relevant? Whether it is relevant that the respondent number 9 herein decided not to contest the writ petition in 1374? Whether that is relevant? That is not relevant. And therefore, there is no material. The material facts, that is, the material which are now disturbing his rights or encroaching upon his rights. Those materials, where are those materials? Ashok, I am submitting before this honorable court, where are those materials that the suppression of it has been so grave that it is curtailing his right today? None. We have also heard about necessary parties, that is, without whom being heard, the matter cannot be decided. Then today my learned friend will say it was decided with regard to SNG. Now SNG should be made a party. My learned, the petitioner has also suppressed that SNG recommendation was challenged along with mine.
All right. Those are your submissions?
Yes, your lordship. On material suppression.
That's right. That's his only
on
point.
Material suppression. Since he has referred.
That's his only point.
That's his only point. And now, your lordship, I'll make one submission provided I am allowed to.
What for?
Lordship, if I'm allowed to. Lordship, since this material suppression, there was an allegation that I have made material suppression. It was an allegation. He can always file a petition, maintainability petition. One can always file the same. Your lordship, since he has not been able to point out a single point with regard to material suppression, and moreover, he has made substantial misleading statements. Your lordship, his application, if at all, is to be dismissed. If at all, it should be dismissed with cost. That will be my submission. Because he has taken the court for a joyride.
All right.
Lordship. Well, only with regard to maintainability, that's right. All my submissions.
Precisely on maintainability, that too what has been reflected from his application. That's all.
Yes, lordship, because if this paragraph 12, if he has read, I am distinguishing in apropos his can 1. I'll read the last line. If he withholds some vital or relevant material in order to gain advantage over the other side, this goes not against me, it goes against him. He has not disclosed that on 3rd, when the matter had appeared, he chose not to appear despite service. And what prompted the authorities to issue the consent to operate, which was rejected on 31st December, immediately 3 days after the writ petition was taken up, he chose not to appear.
Again on merit. Again on merit.
Not on merit. Suppression. His suppression.
All right.
That he should have indicated. If I am also liable to come up with clean hands, he should equally be liable to come up with clean hands because the law says so. If he withholds some vital or relevant material in order to gain advantage. Now, Lordship, who is at an advantageous position?
All right.
Relevant material in order to gain advantage. Now, while disposing of 1374, I have not gained any advantage. Neither my learned friend has been deprived. But in the present writ petition 443, he has suppressed material facts which has devolved into gain advantage over the other side. He's, to the best of my submission, he's my other side. Then he would be guilty of playing fraud with the court as well as with the opposite party, which cannot be countenanced. That is
Okay.
my submission.
Okay. Anything further?
No,
Nothing further? Okay.
Lordship. On the maintainability,
Yes. Nothing. Anything on law?
My lord, just that NGT Act, my lord, they should have approached that court, my lord, the appellate tribunal. And my lord, they have sought for in challenging the environment clearance, my lord. So the specific appellate.
No, nothing on facts.
No, appellate provision, my lord. The appropriate authority to challenge the environmental clearance that was granted in my favor is the National Green Tribunal, my lord.
No, but you have not taken it at the first instance.
But my lord, it's still the point of law, my lord. It goes to the spirit and, my lord, the merits of the case.
Acha, once more, once again, you please make your submission with regard to this appellability.
Lordship,
Let us read. You read 16.
Lordship, before reading that, your Lordship not only consent to operate. We are affected by a government order. That's why I have to come before the writ court. What is the government order?
Government order? Show
Lordship.
me from your prayer. Show me from your prayer.
Lordship, from the writ petition.
Show me
This
from your
is
prayer.
arising out of.
Show me from your prayer. Show me from your prayer.
Lordship, kindly takes page 128.
Kindly take show me from your prayer.
Lordship.
Unless it is in your prayer, how can I see? It may be incidental, but unless it is a specific prayer, it cannot be set aside.
Lordship, since it is arising out of the government order, and that is my case.
And you are challenging the government order.
Lordship, I'm challenging.
Show me
Because
from your prayer.
Prayer is only restricted to this two.
So if these are restricted to these two,
Lordship,
if those two are set aside, it will
Lordship,
amount to setting aside the government order.
Lordship, it will. The
It
government
will.
order will not. Lordship, the government order is passed on the basis of the same.
Which government order? Show me
Lordship,
page.
now I'm coming. Page 128.
128.
One 27th December 2024.
Not the subject matter of the writ.
Lordship, kindly sees page 128, order dated 27 December 2024.
No, madam, this is a general government order.
Lordship, no, Lordship kindly sees the first para last line.
Yes. Yes, read on. The reallocation is based on
distance criteria and
It
as
is
per
a-
decisions taken in
it is a
SLAC meeting held on 4th October 2024.
But it is not restricted for his client. It is a standing government order.
Lordship, this order is made applicable for the respondent number 9.
Maybe.
My beds are deducted to
Maybe.
devolve upon. Lordship, kindly hears. My beds are deducted to go to the respondent number 9 who does not have a plant, and that cannot be decided by NGT under any circumstances. I am not challenging that the concept.
Why it cannot be decided by NGT? It's an appellate forum.
Lordship, then kindly let my learned friend show the provision of appellate forum. Lordship, the next line kindly Lordship takes.
No, you better
All the-
take section 16. Let us read together. Take section 16.
Lordship.
Take section 16.
Lordship, Lordship kindly grants me a moment. Page 130. Lordship, I have not finished placing the same. Lordship, 128 is a continuation which continues till page 130.
Correct.
So, Lordship, herein the list of the facilities where the operators are given which are to operate thereafter.
Correct.
Lordship, these are the government orders which are given effect to once the consent to operate and the other authorization and such are issued. Lordship, thereafter coming to section 16H. 16H.
Madam,
Lordship.
Let us read 16H first.
16H, Lordship.
Kindly take section 16.
Tribunals to have appellate jurisdiction.
Read on.
An order made.
Any person.
Any person aggrieved by.
Now come to H. Come to H.
H, Lordship.
Yes.
An
Any
order
person
made.
aggrieved by an order made.
After the commencement of the National Green Tribunal Act 2010, granting environment clearance in the area in which any industry's operation or
So here, environmental clearance has been granted.
Lordship.
In favor of respondent number 9.
Lordship, now it is the consent to operate and authorization which are granted.
Madam,
6th
please,
March.
let us go one by one.
Lordship.
So, unless environmental clearance is granted,
Lordship.
it would not have traveled up to the stage of consent to operate.
Consent to operate, consent to establish, authorization.
So,
Nothing.
it would not have traveled up to that stage.
Lordship.
Correct. So, granting environmental clearance in favor of respondent number 9 has made you aggrieved.
Lordship.
Then, in the area in which any industry operation process, class of industries operation process shall not be carried out. Shall not be carried out. You say that respondent number 9 shall not carry out its business
Lordship.
because of that distance factor.
Lordship.
That is your case?
Lordship.
Correct. Or shall be carried out.
Lordship.
Subject to certain safeguards under the Environment Protection Act.
Lordship.
Now, these Environment Protection Act includes the rule of 2016, which prescribes that 75-kilometer bar.
Whether it includes or Lordship the very enactment of the 2016 rules, whereas the biomedical rules was published under notification by the government in the such and such regulatory framework for management of biomedical waste management.
So you
the
say
exercise
that
of the powers are conferred.
You say that this 75-kilometer point cannot be taken before the appellate tribunal.
No. This is the Lordship kindly takes the rules.
Yes, let us read the rules that it is not in terms of this. It is
I am not
what is the
aggrieved by
source of the rule?
environment clearance only.
What is the source of the rule? Let us see.
Lordship, page 59.
What is the, in exercise of what power this rule was framed?
Environmental Protection Act. Section 2A defines Act as Environmental Protection Act.
Let us see the
Page
rule.
59.
Kindly come to 59, third paragraph.
Third paragraph.
Yes,
and
read on.
whereas in exercise of the powers conferred by section 6825 of the Environment Protection Act 1986, which is the same here, the central government published the draft rules in the Gazette, wide number such and such dated 3rd June 2015, inviting objection or suggestions from the public within ATO, copies of ATO were made available to the public. So,
in exercise of this rule, power under this rule, the rule has been framed out. Sorry, under the Act, Environment Protection Act, the rule has been framed.
Lordship, the Lordship, if I'm a Lordship, may I read it, Your Lordship? The central government published the draft rules in the Gazette dated such and such, inviting objections or suggestions. It was only to this effect.
Madam, please have some limit on your submission, madam. Please have some limit.
Lordship, the rules are arising out of the Environment Protection Act 1980.
Then why not the appellate provision is applicable? Have some limit.
Lordship.
Madam, you make your submission,
Lordship.
but don't make such submissions which is absolutely an arbitrary submission.
Lordship, I'll restrain myself.
This rule was made under this 1986 Act.
1986 Act.
Correct. Now, kindly read 16H.
16H, Your Lordship, it says one is agreed.
Either shall not be carried out or shall be carried out, subject to certain safeguards under the Act. Now,
Lordship.
these rules comes under the Act.
Lordship, Act, Environment Protection Act 1986.
So,
From
if
there,
you allege the violation of the rule, can you not sustain your appeal under 16H? And these are all factual disputes to be gone into. Whether 75 kilometer or not, whether 16.6 or not, whether the plant was established, then consent to operate came or not, or beforehand it came.
Lordship. Therefore, on 16H, Your Lordship.
Yes, now you make your submission on 16H.
Lordship,
Yes.
16H, since it has been pointed out, it appears to be an alternative provision.
Correct.
Lordship. Now, there are judgments which categorically states.
Madam, the source of all law is Whirlpool as of now.
Lordship.
Is Whirlpool.
Lordship.
Right? Now, you show me the violation of Whirlpool. You show me that it comes within the four corners of Whirlpool. Show me.
Lordship, kindly.
The four things that wholly without jurisdiction, it is not such. Violation of natural justice, that hearing has not been granted.
No.
It is not such,
No.
because that stage has not yet arrived.
Lordship.
That stage has not yet arrived. Arbitrary exercise of power, matter of facts to be gone into in the appeal,
Lordship.
even if it is there.
Lordship.
Why will you not go and apply before the appellate forum?
Lordship, there is a ground of alternative remedy, Your Lordship.
Yes.
Then also, Your Lordship, I am covered under Article 226 because here.
Madam, after Shottavati tandem, the two
Lordship.
things.
Lordship.
Two things. One is Whirlpool.
One is that 1998 8 SCC Your Lordship is referring to.
Yes, that's Whirlpool.
Lordship.
Second is Shottavati tandem arising out of Section 17 of the Surface Act.
Lordship.
So why will you not go before the appellate tribunal?
Lordship, the appellate tribunal only.
His application on suppression may succeed, may not succeed.
Lordship.
Right?
Lordship.
That I will have to adjudicate. But you tell me, why will you not go to tribunal?
Lordship. Now going to try. Lordship, there is no harm in one approaching the tribunal only with regard to consent to. Lordship, it is with regard to environment clearance.
No.
It is not that, Lordship, only environment clearance is provided.
No.
Lordship, kindly.
Granting environment clearance. So you are not agreed by the environment clearance?
I am aggrieved, but today.
Then why will you not go?
I am aggrieved by consent to operate and.
Followed by? Consent.
Followed by the environment clearance.
Matter ends. If you succeed that on your point that environment clearance was bad, consequently consent to operate will be bad. But if you do not challenge the environment clearance is bad,
Lordship,
Cannot challenge the consent to operate is bad.
Lordship. Lordship is restricting me to the prayers of the writ petition.
No, if I hold that alternative remedy is available to you, first I will have to decide his application.
Lordship.
Right?
Lordship.
So application on suppression, I will have to decide.
Lordship.
Then the second point, alternative remedy. Then the second point, alternative remedy.
Lordship, now there is a third point,
Yes.
which the prayers are not only restricted to environment clearance. The prayer, page 55 of the writ petition.
Yes.
Why I was pointing out page 28.
Yes, show me.
Page 128.
Yes.
Why I was pointing out page 55 kindly reads the entire prayer.
Yes.
Page 55
show me.
and the Lordship. Prayer 3, last line. And the petitioner to operate as the existing CBWTF in zone 1. Now these points which are arising out of the government orders cannot under any circumstances be decided by the tribunal. Now what is
So
the
very well,
difficulty?
I will restrict this writ petition only to that extent.
Lordship.
Which means
We
you are
are
accepting.
affected.
Which means you are accepting consent to that first part of clearance. You are accepting that. Or you will only fight on consent to operate.
That cannot have piecemeal. Lordship,
Of
kindly.
course. So that is why you have
Lordship.
to travel to. So you have to travel to the appellate authority. You have to travel
Lordship,
to.
the appellate
Granting
authority is
environment-
restricting me only to environment clearance. Lordship, may I try to clarify? Lordship, may I? Now, Lordship, coming back to the rules, coming back to the 2016 rules, what has prevented, Lordship, even I am aware that what can be the appellate authority or not. My learned friend, the Pollution Control Board, if at all aware, they would have indicated it at the stage of 1374 only.
No.
Lordship, I am not making that submission to be considered. Lordship, what is the difficulty which is arising? The implication of the rules. Lordship kindly takes page 63 of the writ petition.
Yes. Yes.
Lordship. Page 63, last 5A.
Yes.
5. The duties of operator, that is us,
Yes.
to take all necessary steps for ensuring biomedical waste collected from the occupier is transported, handled such and such
Yes.
without any adverse effect to human health and environment in accordance with these rules and guidelines issued by the central government, as the case may be the Central Pollution Control Board from time to time. Your Lordship, now this issue is not only arising out of this functioning, because pursuant to this consent to establish and operate, the number of beds which are allotted to the petitioner, which ought to have been 10,000 within 75 kilometers. Now
Madam,
this has
these
gone
are all
down.
these are all factual issues. Go and
Now,
try it
these are-
before the
these are-
appellate
no, Lordship,
authority.
No, Lordship, this cannot be decided by the appellate authority because this is arising out of the government order.
Madam,
I am-
if you say that this granting environment clearance is bad, therefore the resulting effect consent to operate is bad, you have to go before the tribunal. Now enough.
Lordship kindly takes your Lordship from the stage of gap analysis.
All right.
Lordship
Now
kindly
let me
takes
pass,
that from
madam, let me now pass my order.
Lordship, Lordship kindly takes the rules.
Yes.
Lordship, the rules explains it is not that only the prescribed authority, page 66, kindly takes your Lordship. The rules clarifies whether I have to go before this tribunal or I have my jurisdiction before this honorable court.
Very well. Very well. Let's see. 63.
Page 66.
66. Which rule, madam?
Page 66, rule 9.
Yes.
Page rule 9. Prescribed
Prescribed authority.
authority. Prescribed authority. The prescribed authority for implementation of the provisions of these rules shall be the State Pollution Control Board in respect of State and Pollution Control Committee in respect of Union territories. Lordship, there are diversified committees, Your Lordship. It is not that my relief rise before the tribunal. Today I go before the tribunal.
So you mean that the authority who has granted the clearance,
Lordship,
is not an authority within the rule, within this rule?
Lordship, this rules has two authorities. It is not only the Pollution Control Board. It is the SASC committee, the state government and the Pollution Control Board. Lordship, there are the three authorities. What is preventing me? Lordship, what is preventing me? Lordship needs to hear me, Your Lordship.
Yes.
Lordship, now the procedure for authorization, page 67. What I'm aggrieved by, only environmental clearance is not the only point which I'm aggrieved by.
So you cannot agitate this point before the appellate authority.
Lordship, it is debarring me because it has the past pursuant to government orders. It is, Lordship, it is there where it is restricting me.
Government pursuant to the government orders, but by which authority?
By the secretary of the health department. By the secretary, I am affected by the orders passed by the secretary of the health department.
He is not amenable to. He is not amenable to the
no, Your Lordship. Perhaps this order which I have referred at page 128, this order I cannot go and challenge there. Page 128, kindly seize, Your Lordship, which is curtailing my beds. I am not aggrieved by only of this. It is the entire conduct, starting from the stage of gap analysis. Why am I restricted only to environment clearance? Why not gap analysis? Why not consent to operate?
Very well.
Why I am stuck at
Let us now read your prayer, because I cannot go beyond the prayer. Right?
Lordship.
Read your prayer. Come to writ petition, read your prayer. I cannot go beyond the prayer. Come on, let us read it. Read on.
Lordship. Lordship, and another provision, page 70.
Please read on your prayer, madam.
Yes, Lordship.
Concentrate your submission on prayer.
Are writ in the nature of mandamus, prayer 1, commanding the respondent such and such to forthwith and or immediately withdraw and or cancel and or set aside the environmental clearance dated 1/9/2023.
So it's amenable to appellate. It's
Lordship.
amenable to appellate jurisdiction.
Lordship, I bow down to that.
Read on.
Now, the consent to establish dated 13 September 2023.
Which is equal, which is also amenable to appellate jurisdiction.
Lordship, perhaps this is not there, Your Lordship.
Because if your environmental clearance goes, if that is set aside, consequently consent to operate will be set aside.
Then, Your Lordship,
if your environmental clearance remains, then also consent to operate can be examined by the appellate tribunal. Then
Lordship,
also
that
it can
is
be
what
examined.
His Lordship is concluding, Your Lordship. I will not trouble Your Lordship with that.
No question of concluding, madam.
Lordship,
This is what I am deducting from reading the law. I may be wrong, so that you test. I don't mind. But,
Lordship, if that is so, if environment clearance I have to challenge before the tribunal,
yes.
Lordship, then in this writ petition, I have also started from the stage of gap analysis. Then why am I not aggrieved by the same?
Madam, gap analysis is one of the challenge for granting environmental clearance.
Lordship, I bow down to that.
Yeah.
So environmental clearance is coming in the midway. Now today we have traversed.
So the gap analysis will be a point before the appellate tribunal that look at you have failed to come to a correct conclusion with regard to gap analysis. Therefore, the environment clearance is bad.
Lordship, if that is what is your Lordship is concluding, your Lordship, then your Lordship is closing the doors for me. I have only one door, environment clearance. Now today I'll have to go before challenging.
Kindly read your prayers.
Lordship, kindly hears. Lordship, then today I'll have to challenge the environment clearance. And now today I'm at a stage where the consent to operate and authorization has already been issued.
Yes, you can challenge that also.
Lordship, where is the
Concept
provision? Lordship, where is the provision?
The moment
Lordship,
it is
Lordship, in that event, Lordship, if your Lordship is directing me that at the stage of environment clearance, I could have challenged before the appellate tribunal, then let such consent to operate and authorization, which I had challenged before it was issued, let that be stayed for the timing. Let me try my luck before the appellate authority then.
no question of staying. I cannot. The moment
Lordship,
I will hold, the moment I will hold that the writ petition is not entertainable because of the existence of the appellate authority, and for these reasons 1, 2, 3, 4, 5, 6, I cannot pass any order.
Lordship, in that event, on the
Yes.
point of maintainability, with regard to 16H, only 16H, then your Lordship, I may also be allowed to make my extensive submission on 16H.
Make it. Make it.
Your Lordship, I'll be relying on judgments then on 16H.
Yes.
Alternate remedy point, your Lordship, then I'll have to rely on judgments.
Come tomorrow. Come tomorrow.
Lordship,
Come
your Lordship kindly keeps it day after.
No.
Lordship,
Come tomorrow.
Tomorrow, Lordship.
Tomorrow. That I don't mind.
Lordship, tomorrow.
Come
On
tomorrow.
16H.
I should. In the kitchen.
No.
এখানে একটা add করে দিন, therefore none counsel for the applicant does not press the point for res judicata, the point on the point of res judicata. And Mr. Singhal, and he shall restrict his argument. He has restricted his argument only on the point of material suppression. Res judicata, you are not relying upon. I have said he shall only rely upon the judgment on the proposition of law it has laid down. That is all right. But then again I said, bolun. Huh? I said that. He submits that he shall not rely on the said judgment for his argument on the point of res judicata. He shall rely rely upon the judgment on the proposition of law it has laid down. Full stop. Then, therefore, Chichi. Yes, you don't hear to this, matter ends. Whatever I will pass, I will sign. Chalo.
Grateful, my lord.
পড়তে হবে না শোনার দরকার নেই এতক্ষণ ধরে আমি শোনার পর নিজেদের মধ্যে কথা বলবে লেট দেম টক বিটুইন দেমসেলভস চলো কালকে আসবে আমরা দেখুন কি বললাম material suppression and the existence of alternative appellate remedy.
Yes.
He has concluded his submissions today. Full stop. MS Reshmi Ghosh, learned advocate, appearing for the writ petitioner, has commenced her submissions. She has concluded her submissions on the point of material suppression as alleged by the applicant. Full stop. She has denied that she submits that there has been no material suppressions in the instant writ petition. Full stop. There is no suppression of any fact which can affect the right of the petitioner in the instant writ petition, the right of the applicant in the instant writ petition, as it stands. Full stop. Paragraph, however, learned counsel for the writ petitioner shall make her submissions on the point of existence of alternative appellate remedy tomorrow.
Yes.
Full stop. Paragraph. The matter shall appear under the heading application within bracket top. Tomorrow. Date koto?
Tomorrow is 9th, Your Lordship.
September 9, 2025.
Lordship.
Okay.
Grateful, my lord.
এটা না এর মধ্যে গেঁথে রেখে দিন
Not appearances.
নেক্সট এটা না ও আচ্ছা 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 আচ্ছা
Today it's a 3:30. Lordship, in the principal bench, it's 10:30.
yes. It slipped out of my mind and I was thinking if I can deal with some motions.
I have my motion at item 40 and 41.
Yes.
Grateful, my lord.